Gentlemen, we will go ahead and get started. I'm going to call the meeting to order at 1:04 p.m. This time I will do the roll call. I'll start with Miss Denise Bentley. I understand that she may be running a few minutes behind. So, Lieutenant Beauregard. Here. Colonel Burnett, Commissioner Burnett.
Present here at the KSP headquarters in Frankfort, virtually.
Judge Cutoff. Here. Judge Cunningham. Mayor Gregory. Here. Commissioner McGillick. Chairman Massey.
Present.
All right.
Present from remotely in Northern Kentucky. I apologize for not being there. I'm on the backside of COVID and just didn't want to put anybody at risk.
No, that's okay. The Honorable Mr. McGee.
Hey, good afternoon. Present remotely from lovely Owensboro. Good afternoon, everyone.
Good afternoon. Court take you down there today?
They did. I had to appear before Judge Jones on a homicide case, so here I am.
Chief Monroe.
Present in Lexington, Kentucky.
Honorable Mr. Nicholson.
Remotely.
All right. Thank you, sir. Mr. Pressman. Mr. Ross. Here. Mr. Sanders. Here. Sheriff Scholler. Here. Miss Bentley. Hey, yes, ma'am. Detective Thomas. Yes, ma'am. Chairman Westerfield.
I'm here.
All right. Dr. Wright.
I'm here. I'm remotely from the University of Kentucky.
All right. Thank you, sir. All right. Did I miss anybody, or I think we've got everyone? Okay. Thank you all. And as we proceed through the meeting, if you are attending via Zoom, you might want to wait for a prompt to have your microphone unmuted during the midst of the conversation. And it might be helpful to, I guess there's a raise your hand sort of option to press on or click on if you'd like to speak. That could help with the flow of the conversation as well. I guess I want to welcome everybody to Jefferson County, to Louisville, and obviously thank those that had to make the drive here for coming to the Kentucky Expo Center. I want to thank the Expo Center. I know I got to see Mr. Beck, who I don't know is in the room right now, but for graciously opening up this venue to allow us to have and to conduct this very important work. For the task force members that are seeking mileage reimbursements, please see one of our Kentucky OAG staff members on that front. And if you all have, as you know, the process and routine, if you have any questions during the day, feel free to wave down an office staff member, and we will certainly be happy to assist in any way. Welcome to our public attendees as well, whether you're in person or Zoom. And I want to thank you for your willingness to contribute to our conversation today as well. Note that our public participation policy is posted on our website, and per the policy, up to 5 members of the public will be given roughly 3 minutes to share comments at the end of each meeting, provided they have emailed 24 hours in advance of the meeting. I don't believe that we have anyone that is undertaking to do so, but if something is to change, we're obviously happy to hear public comments if that is the case. At the end of the meeting, we'll hear from those folks again if they are here and would like to speak. Also, you can share any written comments to the search warrant TF at ky.gov if you have anything that you want to say from that point of view. At this point, we'll jump right into our presentations by the Attorney General of Tennessee and his office staff, I'm going to introduce Leslie Price, who is the Senior Deputy Attorney General of the Criminal Justice Section, Nick Spangler, who is the Deputy Attorney General for the Criminal Justice Section, and Scott Wilder, who is the Legal Instruction Officer in Tennessee Law Enforcement Training Academy. So thank you all very much. That presentation will be to inform us about the search warrant process in Tennessee, including a few best practices that they employ there. Mr. Wilder, an attorney and former police officer, will discuss the Tennessee Law Enforcement Training Academy, which is responsible for training 2/3 of the law enforcement agencies in Tennessee, including municipal, county, and state agencies. So thank you all very much.
Thank you, General Cameron. And as General Cameron mentioned, my name is Nick Spangler. I'm the Deputy of the Criminal Appeals Division of the Tennessee Attorney General's Office. I'd like to thank General Cameron as well as Blake and Barry from the Kentucky AG's office for inviting our team here today to share our perspective on search warrant procurement, execution, and law enforcement training in Tennessee. We certainly admire the spirit of self-reflection of this task force, and we hope that our visit today is helpful to the task force goals. Leslie Price and I are both here from the Criminal Justice Section of the Tennessee AG's office, and our experience with search warrants really comes from a place almost exclusively of years of defending criminal convictions in Tennessee's appellate courts. So we mainly deal with defending against defendants' legal attacks against search warrants that led to their prosecution and conviction. So we've got solid familiarity with the sort of narrow body of statutes and rules that govern Tennessee search warrant procedure, but our knowledge is more limited when it comes to sort of law enforcement training on those procedures and rules. So for that reason, we've enlisted the expertise of a third team member who's with us here today, Mr. Scott Wilder. Mr. Wilder is a lawyer instructor with the Tennessee Law Enforcement Training Academy, which, as General Cameron mentioned, is responsible for training 2/3 of law enforcement agencies in the state of Tennessee. He teaches extensively on the subject of search warrants, and he has many years of practical experience to support his instruction on that topic. He served as a Metro Nashville police officer for many years and then worked for the other side as a defense attorney in private practice for several years. He eventually returned to public service as an attorney for the Tennessee Bureau of Investigation for several years before assuming his current post at the Tennessee Law Enforcement Training Academy. So thank you again to Blake and Barry. I think they did a really nice job of explaining to us sort of the purpose, makeup, and interests of this particular group. And so I think Scott is going to use our allotted time to address those previously identified areas of interest. So without further ado, I present Scott Wilder. Thank you.
Morning. Good morning.
Well, I guess we're afternoon here. I gotta get used to this Eastern thing around here.
To gain an hour back. I didn't really know exactly what type of format y'all wish to go, so I kind of just took the 6 proposed questions that the committee sent out and worked on those. So I can just take it question by question, and y'all can stop and ask questions if you wish, or however y'all want to do it. I'm also here for you to just throw stuff at me if you wish.
That sounds great.
All right. So it's what I've done is I've got a legal memorandum that I sat down and answered the 6 questions that y'all were inquiring about. I sat down and put them in this memorandum, and I've got you a book here. As I go through these questions, I'll refer to it. It contains all of Tennessee statutes, rules of criminal procedure, case laws. It's even got an outline of my PowerPoint of what I teach at the academy as well. If you look at it and it didn't make sense, you're feel free to holler at me, and I'll send you the real deal if you want to see it and stuff. But here it is. Ladies first. So you'll hear me referring to various tabs as we get through here. So the first question that I received on this inquiry and was on what training does Tennessee provide to its law enforcement officers relative to the search warrant process, whether at the training academy or on the job. In Tennessee, it requires 480 hours of instruction to be a post-certified police officer in Tennessee. 50 hours of that are directed towards legal. And that covers the 1st, 4th, 6th, 8th, and the 14th Amendments is where the area of focus has to be. Needless to say, a large portion of that is geared towards the 4th. Within those 50 hours, we have a 4-hour block of nothing but what deals with search warrants. Talking about search warrant law, the requirements of them. And as you can see, as this book comes around, in the actual first tab, I believe it is, I have it set out there, It has all of our Tennessee code annotated. We constantly call it the TCA, but the Tennessee Code Annotated, which is your statutory law, and it's a whole block that governs what is required to have a valid search warrant in Tennessee. And that'll be right there in your first tab. One thing before I kind of move a little bit further is I know the word magistrate has various different meanings across the whole country. The very first thing you'll see in here behind this legal memorandum in the first tab you'll see is Tennessee's definition of what a magistrate is. And it actually runs the gamut from a Supreme Court justice down to certain county executives. It's the ones that have the authority to issue search warrants. So before I get into a little more detail on what we actually teach in the search warrant line of things, the Tennessee Law Enforcement Training Academy, where I work, trains the majority officers in Tennessee. State agencies are exempt from the post requirements due to their specialized nature. However, Tennessee Highway Patrol, TBI, state parks, ABC, revenue, they all adhere to this 480-hour post certification requirement, even though they're exempt from that. THP, TBI, they far exceed that, almost doubling those hours up into the 900 range somewhere in that regard. So within Tennessee, we have a total, I think it's 11 academies. I may be off. Your major cities, Chattanooga, Knoxville, Nashville, Memphis, they all have their own academies. THP has its own academy. TBI has its own academy. And then we have 3 community colleges that run post certified approved academies as part of their criminal justice conference. However, should all of those go away tomorrow and said, we're done with this business, we're out, Toledo, Tennessee Law Enforcement Training Academy, where I work, has to remain by law. It is the statute mandated training academy within the state. So what they actually cover at these other academies that I've talked about when it regards to search warrants, I can't speak a whole lot to other than THP and TBI, where I also teach as part of the cadre from Toledo that goes over to them. So I know what they teach at their programs because I help teach them. But as far as Metro Nashville, I graduated from their academy, but you're talking 96. We just touched on Fourth Amendment, and search warrants at that time were for detectives, and don't mess it up, rookie patrolmen. So that's kind of how that went. But what they're teaching now, I can't speak to that portion of it. So when we get to the 4-hour block of the search warrant criteria at Toledo, I start out with a history of the writs of assistance back in England and how those all came to be and why we broke away and how the Fourth Amendment was important to the evolution of the United States and what search and seizure means. And we start going from there. As we move, we gradually move into that, into MAP versus Ohio, and talk about what the exclusion rule is, because you've got to understand, we're talking about rookie patrol officers, and a lot of this is new to them, and they don't know anything about what the exclusionary rule is. And then once we get done with what exclusionary rule stuff is, we start focusing on Tennessee law specifically. And we start with the statutes that you have right there. Our statutes governing search warrants start at 46101. And we also have 40-1106, which gives you the definition of what a magistrate is in Tennessee and who can authorize a search warrant. So we'll start talking about those things. As we start going through those, we touch on each subject in detail, and we talk about what exactly probable cause standard is. We've already kind of touched this in other areas along the way. And then we start talking about the requirements when it comes to the drafting. You will see one of the statutes that we have in here, and I want to make sure I get it right since I'm supposed to be the teacher on it, is 106, I believe it is. It's the actual form, and it's the template of how the warrant has to be within Tennessee. And it has all the criterias, the languages and stuff in it. So all forms of search warrants across the state of Tennessee follow a uniform standard. This is the things that have to be in it, and that template's in there. On one of the tabs, I think I marked it down as the 4th tab, I believe it is, maybe not the 3rd tab. Anyway, I have some actual templates of search warrants in there, and I have a search warrant that actually survived a whole bunch of suppression issues and stuff to give you an example of how a finished product looks as well. But when you go through the search warrant template, you will see where I marry up the TCA numbers that are required per statute in there. So when you see the blank warrant, you're like, number 1, you can refer back to that statute, and they'll tell you that this is talking about number 1 within the actual form in and of itself. Outside of the Tennessee Code Annotated, which covers this block of instruction, we also have a Tennessee Rule of Criminal Procedure 41, and it covers the search warrant material as well. And while the TCA section tells you what your grounds are that you can get a warrant for and who can get a warrant, it tells you exactly what the form of the warrant is, what specific definitions mean, what the probable cause is, the form of the affidavit, examining complainants and witnesses, what the judge's duties are and what they're looking for in the warrant as well. That's listed in there. Tennessee Rule of Criminal Procedure 41 is almost a parallel to that, but more of an actual procedure, I guess I should say, even though it's in the form, it's an actual procedure on what needs to be done. And Rule 41 also gives you some of the service stuff, forcible entry if need be, on the search warrant type stuff. So it kind of goes into more of the practical application as well as the roadmap that's provided in TCA. Once we have gone through the meat and potatoes, I guess I should say, with the rookie officers or troopers or whoever it is we're teaching, and we've talked to them about what the TCA requirements are of the warrant in order to get the form correct, we start out real slow with just giving them a fact pattern. And typically it's always the same one, you know, it's like, okay, I'm on patrol going down Lebanon Road, which is Highway 70, going through the heart of Nashville. I'm traveling westbound. And all of a sudden I'm passing a car at 10 o'clock at night, driving without lights on. So I conduct a U-turn, get behind the car. And then as I get behind the car, I notice he's going over the center line. He overcorrects and really sweeps over the fog line. And you know, he's speeding. We put all that stuff in there. And then we decide to stop the car. And as we walk up, empty beer cans in the back, maybe vomit on them, you know, red bloodshot eyes. And I tell them, now, what have I just described? Well, that's a DUI. So then we start giving them examples and fact patterns and have them start working on their probable cause statements. Once we get the probable cause statement done, we have already had criminal procedure with them where they've got their code books and what the elements and stuff are of the crime. We will give them their pattern, whatever their scenario is, and then let them marry that up to the code book that we've given them and show them how you match up. Do you have probable cause of this offense for your warrant? Match it up to your elements in the statute book. So we'll have them, and typically when we're dealing with just your basic patrol officers, first timers, even the troopers, most of their warrants are going to be relegated to DUIs or other more simple type stuff. With TBI, it becomes a lot more in depth, where they'll be working homicide scenes, maybe white collar crimes for records, a lot of sensitive stuff where you may want to consider having a record safety officer, which we run a lot of in Tennessee when it comes to. So if you're investigating, let's say, a doctor or a lawyer or a judge's office where there may be confidential records involved, they're good about placing what's known as a record safety officer in between the investigating agent and the actual files, so that you can have somebody that can look at it and go, this is confidential, not relevant, this is evidence. And that way somebody's confidential medical records or something that's not involved in the investigation stay protected and seared. So we run a lot of confidential records officers and those type of cases when involved. So let's say after we work through some of these basic outlines and we've had them work on their probable cause statements, we do not spend a whole lot of time having them fill out the rest of the warrant because the template is kind of self-explanatory, but we do sit here and put it up on the screen and be like, what goes here? Oh, that'd be my name. Okay, this would be my agency. And we all kind of do that in a verbal way. So once we've got them confident to where they're working on their probable cause statements, we will start going through the things that will absolutely make a warrant fatal in Tennessee. And that's the failure to follow a lot of these guidelines. Not getting it served within 5 days. Tennessee has a 5-day service rule that they have to do it in. And it's kind of a unique way that they judge time on it. They want you to be all on the same sheet of music. So if you went and got the warrant signed at 1:30 p.m. on a particular day, you don't have to count 1:30 p.m. 5 days today. The time does not start running until midnight that day. It runs. So everybody gets a full 5-day, 24-hour periods, and it will die on that night. Tennessee does have the capability to do day and nighttime service, but we strongly, just because you got it, should you do it? And everybody's like, no. Yeah. So we really impart on them, just because you've got nighttime service, ability to serve a warrant, we expound on them. It needs to be a situation that that's what it dictates, because we really strongly advocate daytime service. And we always strongly advocate having a marked unit as the lead vehicle that goes up and parks directly out front, making a bunch of noise, police, whatever it takes to get that identification going. But I'll get into a little bit more that here on. So after we've gone through the basic search warrant stuff, and we've got them kind of comfortable with knocking out a basic search warrant, once they get out on the street, if they need any help, I know all of the Toledo instructors at our academy, we're very forthcoming about providing our information as somebody they can always reach back to later on. So, being that rookie guy where you got that name tag that says serving since breakfast, they're not always be like, oh, I don't want to go bother Sarge, man, So we always make ourselves readily available, and I get calls weekly. Hey, I'm working on this. What would you help with, or whatever? So once they're out on their own, we make ourselves available. If they're in some of the more rural parts of the state, they always have a trooper that's assigned to that district. Granted, a lot of their stuff will be pertaining to getting into black boxes for accident investigative type stuff. That's what we call them, or DUI stuff. And then you always have your TBI agents that are assigned to that area. And we know they've typically had a lot of warrant experience, and they can go to them. They can also go to their judicial district and seek out a DA or an ADA. And in Tennessee, I don't know if Kentucky has them, and I apologize for not studying beforehand, but we have the DA's office run a lot of judicial narcotic task forces. And typically your narcotics task force officers that work for the DA, they write a lot of warrants. So we always open up the opportunity to them that here's people that you can go to seek out help. And the police kind of tend to watch out for each other. And so we always go out of our way to help people that may be having a hard time so they can learn it right. And you're bringing up a good group behind you to help you in that regard. Outside of being able to talk to people within your particular district, we have a lot of the kids that come in from our more rural sections that if you ask them, Pickett County, Fentress County, some of our more rural areas, hey, at midnight on the midnight shift, if you have a homicide or you have a robbery, who's coming to help you? It's me. I'm the patrol officer and the detective right there. Unless the DA activates TBI to come in and do it, it's all on me. So we really extend a handout to those and be like, hey, if you need help at night on a warrant or something like that, do that. In addition to what we teach at Toledo on a basic level, at least once a year, we try to offer nothing but a search warrant writing school. It's 40 hours. It's still your warrants, but we throw in a whole lot more difficult scenarios that they have to work through. So you might be able to have dispatched on a shots fired with an exigent circumstance, go in and find a body. You've got to start working that homicide. And then you've got to start working more fact scenarios to figure out, do I need a warrant here? Do I not? Then within that, we will start escalating the complexity of the investigations and the things they got to start getting into. This will get into having to write cell phone warrants, computer warrants, Facebook warrants, things like that. So we carry them through just a ton of different writing scenarios. And in that process, we typically have, it's usually me, sometimes I can get DAs to help, or other friends that are attorneys act as the magistrate that they go see. And when they write their warrant, if it doesn't reach the criteria or something's off, we'll deny the warrant, go back and write it again. Or, hey, you need to sit here and work on this, and here's where you're deficient, let me help you. So we will totally do that. And we often play a game as making it real life. I know TBI does this. They will assign somebody to be the magistrate during the day and be like, you need to contact so-and-so, and they'll really have to go hunt them down. I mean, they could be out doing whatever, and they'll make them go find the judge and sit down and go through it. So the search warrant school we do is pretty in-depth. Every time we post it, I have to kind of pick a week where I don't have my other teaching obligations to do, but I have always been amazed at the people that sign up for it. I'm like, people are signing up to get tortured on a bunch of writing all week long, so it's like, but it always fills up, and they come from across the state to do it. In addition to the search warrant writing school, we do a new investigators course. And within that, we have a 16-hour block of search warrant. It's a reduced form of that search warrant writing school. class that they do, and they will work on exploiting scenes, collecting evidence, and they'll write a warrant or two in that one. And I do several days worth of lecture on how to write various warrants and that. So when we go into question number 2, any questions on number 1? Anybody? Yes, sir.
You mentioned that back in the day when you were trained, they didn't want patrol officers mucking around with this, leave that to the detectives. And I take it, you kind of answered this, I think, that you don't currently have a mandatory thing in Tennessee where it has to be reviewed by someone like a lawyer or.
No, sir. It does not. There is not a mandatory requirement that it has to be reviewed beforehand. And I've actually touched on that here in a second. Metro Nashville, where I started life as a police officer, recently had an incident where an investigation did not go as planned, and some investigation went into researching where the person was they were wanting to look to. So in turn, they served a warrant at the wrong house. Nothing bad happened. They just went to the wrong house. So Metro Nashville just here recently, I've still got a lot of friends over there. I don't have the policy. I'm trying to get it. I'll still continue to work on that to see if I can see it. But they are the only agency within the state that I am aware of. There may be others, but they are the only one within the state of the agency right now that I hear is requiring a search warrant to be reviewed at the deputy chief level prior to. But other than that, Tennessee's unique in the fact that it's judicial districts. There's 31 of them. It's unique in the fact that each judicial district has its own personality based upon the judges and the DA that's elected in it. And each one of them, each elected DA has its own personality, the way they like to do things. So
That may not be as unique as you think.
yeah. Well, I'm originally from Alabama, and I don't even think they got anything there, but you know. So, but yeah, it's unique in the way that how it's set up across the state. And that even goes down to the evidence collection that I'm going to talk about here shortly. Did that answer your question?
Yes,
sir?
thank you. Sir,
Yes.
You stated, you kind of pointed out that you all down in Tennessee have both, you authorize day service or night service.
Yes, sir.
Led me to sort of a illusion that somebody considered that in like a legislative hearing and so forth. Do you recall why were there specific reasons that they determined in Tennessee to maintain the night service?
I do not, sir.
Okay.
I do not. The statute that's on the books, it's in the 40 code, and I think it's also listed in the rules of criminal procedure. I can go down there and look, and I apologize for not looking, but it will have the date that it was enacted. But being involved in this a while, I have not heard of any changes within the past decade that I'm aware of. So it's
in regard to that, if I provide you my email address, is that available by electronically?
Yes, sir. Or y'all are welcome to make copies of it, whatever you want to do.
Okay.
I just want to, I'm whatever. I'm happy to do it. And I give you my card, or I pass out cards to everybody. If y'all want to contact me, whatever you want to do, and I'll be happy to send you anything. And you're welcome to take whatever you want out of that, make copies of it today if you wish.
I don't have a copy machine.
I have no trademark law on this, so it's all right. Anybody else? All right. So I'll move on to number 2 then. And the question was, what does Tennessee expect will go into investigation prior to a search warrant being sought? I think I largely touched on this, but we're real heavy on the fact that what are you wanting to get a search warrant for? And we have a case in the state versus Reed. You'll see it mentioned in my outline right there. And Tennessee says, in order to have probable cause in Tennessee, the analysis that we use is, you've got a crime. What is the item you're looking for? And how do you know it's at this location? So you kind of have to make this triangle between crime, item, and location. And Tennessee's kind of like, that's probable cause that we're looking for. So it's what we advocate that the officers do as a best practice, is to take whatever crime it is they're investigating, sit down with their code book, look at the elements of it. I'm not sure about a Commonwealth state. I apologize for that. That's ignorance on my part. But in Tennessee, if it's not the code book, it doesn't exist. It's all statutory driven. So we will sit them down with the statutory book. What is you're investigating? What are the elements of that? And what do you have from your facts that lend to that probable cause in that? And let's start going with the warrant from there. Once they have that probable cause, we are adamant about, do not hesitate to go talk to somebody about it. if nothing else, have even the guy that's more junior to you sit down and read through it word for word for word and just look for errors. This memorandum that I'm passing around right here, I can't tell you how many times I proofread that thing. And I still found a whiff that I was missing this morning and redid it for you anyway. You'll probably find one anyway. But we're adamant on proofreading. And I even tell the kids, I go, hey, they could send me back out to the street tomorrow. And if I work with you and I bring you a warrant, if you want to make me mad and I go, hey, would you mind reading this warrant for me? And you go, yep, looks good. I'm going to be all over you because I really want you to sit down and stop me from making a mistake and pay attention to it. So we're big and advocates on, hey, go talk to a senior officer, find your task force officer, find your trooper, find your TBI guy, go talk to the DA and just have it proofread and go over it if you have the ability to do so. If not, put it up for a second, then come back to it and read it again and look for your mistakes and make sure it marries up to your code book, your probable cause. When it comes to Tennessee, I don't know if this is applicable to y'all or not, but just in case it is, when I was at TBI and we would have cross state lines investigations that had to happen, Tennessee requires that any search warrant that's going out of state be written to Tennessee standards or it will be excluded. So, and the example I put in the memorandum was if TBI is going over into Alabama to conduct a search warrant and they're like, oh, no, yeah, you know, Alabama doesn't require all the stuff we do. We'll go with the easier warrant. They come back here, it will be excluded. They will pitch it. Now, if there was another state, and I'm not aware, if they had a higher standard than Tennessee, you could write it to that one, but you have to write your warrant to Tennessee standard to go out of state. Of course, a judge out of state has to sign it, but it has to be written to the standard that's put in the code or they'll exclude the evidence. Let's move on to the next one. Tennessee does expect, even though we just recently went to the Illinois versus Gate, or what you call the totality of the circumstances test for verifying information and corroborating stuff of witnesses and stuff within the body of your probable cause. Tennessee for the longest time was still Aguilar-Spinelli test that had the two prongs, you know, veracity and basis of knowledge. Even though we've gone to the totality of the circumstance test, a lot of people still are really adamant about hanging on to the old, more stringent two-prong test when it comes to receiving information from a second hand. They really want some independent verification on, well, who is it and how do they know? How do we know it's not somebody's got a bone to pick with so-and-so? So a lot of independent corroboration is really pushed on verifying facts. And depending on the judge you get, most of them are really good about questioning that section. Well, this person right here, what's their connection and how do they really know? Well, they just told us. You know, they get a little pushback on that. So Tennessee's pretty good. And I'm basing some of this on when I've gone and sought warrants. When you get questioned, kind of where the sticking points are. So when you see that Tennessee is still adamant on the two-prong test under Aguilar-Spinelli, we have adopted Tuttle, the Illinois Gates test, but there's still a lot of places where Aguilar-Spinelli two-prong still comes into being. So any questions on that second part? Anyone? All right, I'll move on to number 3. If somebody's got anything, just holler. What is the internal and external review process for a search warrant? This goes to what you were asking earlier, sir. Metro Nashville Police is the only one I know right now that has a search warrant review at the deputy chief level. I'm not saying there's not another agency that doesn't, but that's the only one that I'm aware of at this time. The internal, external review prior to search warrant service, judicial district to judicial district. And in fact, I was telling my colleagues here on the way up here, when I'm teaching the newbies and the whole thing, the one thing I can always get them to relate to is I was like, pretend that you're working at Subway and you're the sandwich artist. The DA has to eat the sandwich. So you want to make it to the way that they want it. So get to know your DAs and your ADAs and work the way they want things to be done in that compliance. So Tennessee, Metro Nashville is the only one that I'm aware that has a deputy chief level. Other than that, it largely depends on judicial district to judicial district. But like I said previously, we are strong advocates of having at least one other person peer review your document, at least for the most minor mistakes, and sit down and make sure that probable cause and that particularity statement really exists so that you could hand it to the guy with one IQ and he could walk to the location and find it. So those are the things we really harp on big time. This particularity, probable cause, and just basic errors. If they need any help, they can certainly ask their area trooper, TBI agent, ADA. They can always call us at the academy. We're always happy to help. Tennessee also runs a fairly proactive, in my standards. My colleagues here might be able to answer a little bit better, but I consider it to be a very proactive defense bar. And they are real quick with suppression motions and real quick to jump on things, which is their job. So it acts as a real good check and balance. I know a lot of defense attorneys. I knew a lot of them even before I went out and did self-practice for a little while. And I was always amazed because you get the certain image or the stereotype of what the defense bar is like towards cops. And to be honest with you, I found every one of them to be some of the best help I ever got in my life. So if I did something that they were attacking me on the stand about, they'd be willing to talk to you about it out in the hall afterwards. Like, oh yeah, well, here's what you need to do next time. This is the kind of stuff. So Tennessee runs a very proactive defense bar, but they're also open and helpful. So that it kind of helps keep that check and balance in, and we all kind of seem to work together in the criminal justice system for what's best for society in that regard. All right, so I'm going to move on to number 4, absent somebody having any questions on that number 3rd question about the internal external review. All right, so this is kind of the one where I've spent a whole lot of time in practical application. What planning takes place prior to serving a search warrant? Most of this is going to come from my own experience and how we did things and what we found has worked well over the years. I can't speak to this is what everybody does across the state, but it is what we advocate people do as a best practice. So the first one I talked about was that Tennessee has the ability to execute a warrant day or night. We really expound upon the fact just because you can serve it at night, does that mean you should? And we strongly press on wait till the daylight, get some sun up, go with a marked car. Everybody's well marked. We announce over the PA, and we really make it plain to who it is before we go. There's 2 ways to look at the service of a search warrant. Tennessee, most places that I'm aware of, and we strongly advocate the use of, is what's known as a threat matrix, where it works on a point value system and what the threat is at the location of the service. Having dogs, a lengthy criminal history, all increase the points. And last time I looked, the threat matrix system was once it hit 25, they recommend service go off to either a tactical unit or a SWAT team. If you're bringing in a unit to help and assist with the search warrant, it is an absolutely fatal flaw in Tennessee that whoever the magistrate signs, what we call deliver the warrant to, he takes the warrant, the magistrate puts in the officer's name, signs, dates, and times, all the stuff you'll see in the code in there. Once he hands that back to the officer, he keeps a copy. The officer leaves with 2 copies. So you're required to make 3 copies of a warrant in Tennessee. Go to the judge, he signs all 3 of them. You don't pre-fill them in for him. He fills in his blanks, and they all have to be original just to prevent the application of duplication. So once he keeps his after the first sign, you leave out with 2 as an officer. If that judge does not fill out the blanks that he's required to fill out, where he puts in the officer's name, his signature, hour, date, and time, that warrant is dead right there. It is a fatal warrant. So that's kind of one of the checklist areas we tell them to look out for. When the judge signs it, this is where you need to look for. And if he doesn't do these things, that warrant is dead right there. You can't go forward. You need to rewrite it or go back and approach it and have it squared up. So that's a fatal flaw area that we call it. I've already mentioned that Tennessee gives you 5 days to serve it. So once an officer has decided that they are going to have to bring in, based upon maybe a threat matrix point system or whatever the circumstances may be at the sign of the scene, we advocate to them make an extra copy of the warrant, contact the unit that you're going to have assist you serve the warrant, and give them a copy of the warrant as soon as possible. Let them start working through it and reading it away from you to make sure probable cause exists, particularity of where the place is going to be is there, and everything in the warrant looks valid on its face. And then y'all come back together and start working on the plan that you're going to go through. In Tennessee, it is another fatal flaw if you go and have that warrant signed for execution and you leave out of there, everything's good. You're going to have a unit assist you serve it. The officer that officer, the warrant is delivered to, that the judge gives to, has to be on the scene when that warrant is executed. They can't be, hey, I'll be there in a minute, or hey, I got to go to court, go take care of this for me. There's none of that. They have to be there. Now, Tennessee, we've got case law on it that have to be there. They can be there when the breach is made and the place is brought into control. They can leave and go serve another one and then come back and exploit the scene. But when the execution of the warrant occurs, they have to be present. If they're not, that's a fatal flaw in the warrant right there. So if you've got your warrant, you've decided somebody is going to help you serve the warrant. I mentioned that you give them a copy of it, let them start working through the probable cause, particularity, any errors or flaws that they may see in the warrant independently. Once that's done, we advocate the affiant or the author of the warrant and one person from the assisting team start working together. We used to call them a liaison. That's something I got saddled with a lot because they found out I had a law degree. So I wound up being the legal liaison, and we would start working together on what the goals were to achieve of the warrant. And we'd also start working at looking at the house for any issues we may have had. Roughly a layout. Are there dogs in the yard? Do we see kids' toys that would indicate kids may be home? What is it are we trying to achieve with this warrant? And make sure we're all on the same page on exactly where this warrant's going to go. That includes avenues of approach and leave. And we would typically always either film or take still photos of the house and photos or film of traveling to and from the location, from where we're going to do our pre-raid briefing to the location, so everybody knew where they were going. Once on the scene, we would always put the affiant typically in the first car of the convoy that was going out there. In the first car, it would always be a marked unit. If we had to go out of county, everybody knew what a Metro Nashville police car looked like. But if we had to go out of county and we couldn't get one of those local agencies, we would go find a trooper because everybody knew what the highway patrol cars looked like. But we'd always take something that was obvious as to what the car was. That would be the first car in the stack. Typically, the rest of the team that was going to do the entry would be in the second car. First car, you would have the affiant and an officer driving. Second car, you would have the actual entry team with the liaison that worked with the affiant and that car. When they pulled up to the front scene, you would always have that marked car up front, right where it was in plain view of the house. They typically would hit the button on the siren, go bleep, bleep, bleep a few times, start announcing over the PA, police search warrant, come to the door. Police search warrant, come to the door. When that was going on, the affiant that wrote the warrant would typically get out of the passenger seat and run straight to the location while the entry team was coming up with the liaison leading the way. And the affiant would go, that door right there. And the liaison would double on him, be like, I agree. And then they would go and do that. They would, if there was an outer storm door, the liaison would open that and start a knock and announce sequence. Knock and announce, police search warrant come to the door while the PA is going on too. The team leader typically started to watching the time. And at the appropriate amount of time to the facility and what was going on, then he would ultimately give the command to breach. The announcements would continue in the car until everything was secure in the building. And then the affiant would come in. This is a good time to bring up Tennessee. If you do not knock and announce, it is excluded. Michigan versus Hudson from the United States Supreme Court says you must knock and announce, but it does not arise to the level of the exclusionary rule where we'll suppress evidence. I have several cases in there. It arguably dates back to prohibition. But the most important cases that I have in there right there are Curtis and Fletcher. One's in 90 and one's in 97. And Tennessee flat says, if you do not knock and announce, your evidence will be excluded, period. That's the way it goes. There is, yes, ma'am. If it's not required, but if we're going to use like a SWAT team or a tactical team to do it, we always have one close by in the vicinity, or we have a medic or somebody on the team.
So your mandatory knock and announce, is that by common law or is that written into your code?
The way, when you read the statutory cases in there, it's written into the code. It's mentioned in your rules of criminal procedure. And then it's what the way the Tennessee Supreme Court has approached it when it hadn't been done in the past is like, this is contrary to our interpretation of Article 1, Section 7 of the Tennessee State Constitution, which is essentially our equivalent to the Fourth Amendment. And they say this runs contrary to this. Now, Tennessee came up with, they came up in the case of Perry with 5 exigent circumstances where that can forego. With the knock and announce legislation that's become really prevalent stuff here as of recent across the country, I have talked to a lot of my colleagues at TBI, Metro Nashville, and various other Clarksville and other places that I've got good relationships. And it's been every one of ours consensus down to the board that there is no such thing as a no-knock warrant in Tennessee. Never has been a no-knock warrant in Tennessee. It's like excluded off the bat if a no-knock happens.
Unless it's one of these 5 exits.
Right. And as the way they do it is if you, the 5 exigent circumstances that come up that forego that, you're never going to get them on the front end. You are presumed to have to go, you're going to knock and announce. The 5 exigencies will only kick in once you're on the scene, and that is the circumstance that applies. Once you get, if you go to a search warrant, you've got your search warrant written, you have the legal presumption of reasonableness, the legal presumption with you. If you go and have to use one of the exigencies, you've lost that legal presumption of reasonableness, and now you have to present at the probable cause level, why did you go with one of these exigencies if it's challenged? And the 5 exigencies that came out of the State versus Perry, that case is provided to you in that notebook, is that the people inside know the police's presence and why they're here. It's like when you pull up, they're all on the front porch and everybody goes running back inside, be like, oh. You know, we call it the useless gesture at that point in time. There is probable cause when you arrive on the scene that somebody within the location is in immediate peril of serious bodily injury or death. The third one is that there's probable cause to believe those are inside are aware of the officer's presence and they're destroying evidence. And in Tennessee, the pitter patter of little feet does not constitute destruction of evidence. Neither does just a commode flushing. It has to be something more on that regard. It has to be something that's one capable of being destroyed that you're going after. So if you're running down, you know, a bunch of stolen I-beams, you know, you're going to be able to flush those, you know, so you don't get any of that stuff. So it has to be something that you can profoundly articulate as to why you're doing it. The person inside is armed. You have probable cause to believe that they are armed. And the 5th one is they have a history of violence and the history of violence, and they have threatened officer safety. But those all have to come up to the probable cause standard. So if you go to you're required to do the knock and announce. If you get on scene and the probable cause level exists at one of these 5 exigencies, you can go. But then if you're challenged on, you have to present to the probable cause level why you went around that knock and announce to get that legal presumption back.
So basically, you have no knock warrants, you just do it on the backside instead of the front side.
Yeah, if I carried a warrant and said, I'm asking for no knock, that doesn't even exist. You get it on the back end, yes, sir.
But you have no knock warrants. You have the same thing as a no knock warrant. The only difference is you leave it up to an officer to make the determination of whether or not we want to go with an exception as opposed to asking a judge to sign off.
That's right.
Up front.
Yeah, and Tennessee looks at it in the regards that, well, if you've got that kind of exigency that has to be dealt with on the front end, then you've got an exception to the search warrant requirement on the front end if it's that bad of a deal.
Not necessarily.
Well, I'm just saying that's kind of the way to look at it, yes, sir.
Like your last exigency. Yeah, I don't know how you show up at the scene and
I don't
suddenly
either.
that manifests itself. Now, I'm just saying, that seems like that would be something you could only know on the front end.
Yeah.
You see him behind a window waving a gun, I guess.
Yeah, and that's the only time that I could think of that one, because I know in the warrants that we have done, we never had one where that would ever have been employed. I mean, I think it would almost arise to the level of like, man, this guy's got 2 prior homicide convictions. There he is with a rifle. But even then, where I'm kind of going to go ahead with this here in a little bit on the service and stuff, but this is just good of a time as any, is we are also unabashed believers a lot of times in, why don't you just surround the place up and call them out? Or a lot of times, just based upon my experience, if you're worried about maybe narcotics getting flushed, and we've talked about this, if you've ever experienced like a brick of cocaine, it just doesn't readily go away that easy. I mean, it's like taking a bag of loose flour, dumping it in the toilet and trying to flush it. It just didn't go away that easy. I mean, it kind of cakes up, it chunks, and and typically it's what winds up getting flushed in smaller amounts. So if it rises to that level, then yeah, maybe. But we are big proponents of potentially getting them. I'm sorry.
I just wanted to ask why you were on this area. Is everyone present required to have on body cams?
That depends agency to agency and what their budget affords. We have a lot of rural counties that have not got body cams yet, just based upon a budgetary thing. Most of your major police departments are running them.
Do your state police wear body cams?
I think they're in the process of getting them, but I don't think we have them yet. I know we had some legislation proposed on body cams, but I think it got tied up in fiscal committee on what the actual dollar amounts were going to cost. Yes, but I know like Nashville SWAT team, they always have theirs on.
They're required or they just
Yes.
have them on?
Yes. No, they are required to have them on.
They're required by what? State statute?
I think it's state policy, just department policy.
National policy.
Right. We don't have a state policy yet. There have been several introduced, but my understanding is, and they correct me if I'm wrong, they kind of got bogged down in committee based upon the fiscal note.
Okay.
Because I mean, you're talking about a lot of money for some pretty rural areas that don't have that type of financing. But it has been introduced.
And is that policy backed up by an exclusionary rule?
No, the policy would just be within Metro Nashville.
So what's
or
the remedy?
Yeah, whatever their disciplinary punishment would be on that one. And that I don't know. I can speak to that. But as far as a state, not one I'm aware of at this time. The body cam thing just kind of died based upon monetary stuff. But I do totally expect to see it back next year as they work through it.
You said earlier that the team leader's watching the clock. What is the minimum amount of time that's expected?
Well, when you get into Michigan versus Hudson, the Supreme Court set out some guidance in that one, saying it's largely based upon the size and the location that you deal. In that particular Hudson case, they said 3 to 5 seconds was more than applicable because it's a little one-room apartment. And if you get into like a single wide trailer, yeah, that's fairly. The example I use when I teach the kids, oddly enough, is we always typically have a Williamson County deputy sheriff within the room, which is down around Franklin stuff. It's where all the country stars like. And they all know where those are. And I go, so if, let's say you had to go serve a search warrant, maybe Jason Aldean's house. How long would it take him to get to his door? They go, well, man, it'd take you a while. And I go, yeah, well, if you come serve one at Scott Wilder's house, if I ain't answering in about 5 seconds, it's just not that big of a house. So it's based upon the Supreme Court guidance and what is a reasonable amount of time based upon the size and location. And what are you seeing at the scene? People peeking out. You hear them scurrying around in there. Obviously, they may know something's up and you can do it, but it is based upon a reasonable size.
So you all don't teach a minimum and state law does not set a minimum.
They do not, sir.
It's still like.
It's
other
based
places,
upon the
it's
reasonableness of
court-
the location. Yes.
And court opinions.
Yes.
Got it.
Yes. Yeah, it's just based upon that reasonableness standard. Going back to serving the warrants, we are, like I said, there's no issue. We're proponents if it's applicable to just surround the place up, call them out, get them to come on out. Or if you can catch them separate of the location and just conduct like maybe a traffic stop and take care of the issue from there, then you've got the location that you'll have to go into. Or some other way you can, because a lot of times if it's a normal detective that's working on serving a search warrant, they've usually dealt with somebody at the scene beforehand. And they'd be like, hey, could you come meet me so-and-so? Well, then you've separated them from the location and do that. So those are all tactics that we consider, this is not you've got to do it, but just, is this a tool for your toolbox that it applies at this time? Don't think anybody's going to think you're scared if you choose to hold off. Not everything requires a kick in the door if there's another way to approach.
Mr. Wilder, you mentioned that the affiant must be present at the warrant service. Is that something that's always been a part of search warrant execution? Or
It has as long as I've been an officer, since 1996. It's always been required that they are present. It should be on the end of those Westlaw notes of when it actually got enacted. I'm sorry for not knowing.
I have one other question about you used the phrase threat matrix and it sounded like there's a point system.
There is, sir.
Where's that come? Is that a regulation? Is that
I
policy?
think
Is that
when it matriculated with us, it came a lot of the Regional Counter Drug Training Academy down in Meridian, Mississippi, that conducts a lot of training and stuff like that. It was a thing that originated from out of there. And I could potentially get a hold of one, but it was one that we always used at Nashville. And I know they're widely used across the state because I can typically bring that up with an officer. I go, well, what was your matrix points? And they'd be like, oh, well, it was only a 19 or whatever. And I haven't found an agency yet that doesn't have a clue what I'm talking about.
Okay, and if they use it the way you're describing, that
Yes,
if a certain
it's-
point system is reached, then there's a heightened level of
Yes, sir.
service.
It's a series of questions, and based upon the question, there's a point value attached to it. And then at the bottom, you add them up and it'd be like, here's your total number of points. The recommendation is that you should probably hand off service to a tactical team or something to deal with the increased, whatever the security threat is.
Do we have that?
That's custom, not state law.
No, that is not state law. No, sir. That's just custom and
Okay.
what we consider, this is the best practice. It's not required. You could totally send one deputy into a whole trailer full of bank robbers and he'd be like, oh, we wouldn't do it, but there's nothing to stop. But we do advocate for it. So we kind of talked about some of the alternatives to that. The other thing is if it's what we call less than a dynamic type search warrant, was just like, maybe we're going to go and see some records, or you're looking for something particular in the house that it doesn't carry this enhanced threat risk with it. We talked about, again, the affiant needs to have somebody else proof that warrant. Double check it for the errors, make sure the probable cause based upon the elements is present. Make sure the particularity is suitable, that somebody else can identify this location and it meets those regards. And then you start going through the planning phase, just double check and see if there's any issues about the house, try to understand the layout of the house, the route selection there. As you get closer to the time of execution, maybe have a routine patrol officer just cruise by and double check for anything that may pop up along the way beforehand, about an hour or two beforehand, and do that. But this is also a good place where typically it's that type of situation to be investigated, and they're just wanting to go in to get a particular item, and it's not something that would be considered a dynamic thing. Typically, the investigator has already talked to somebody at the location, and they'll be like, hey, would you mind coming out here and meet me? Or, hey, could you meet me at so-and-so that day? And then you've got that separation from the actual location. And oddly enough, we had many times that we dealt with where you could go up to them and be like, hey, we have a search warrant. You have the keys to your house? We did several TBI that you go help and they'd be like, yeah, absolutely. Please don't kick my door in. They just they'd give them to you and you can go do it once you present them with the warrant. So we always tell them, not everything requires you to do that. Just always think towards, because Tennessee will exclude evidence if unnecessary damage occurs. There's cases where that has totally happened. And I'm talking, it has to be usually something extreme, like, well, the door didn't breach, so let's hook up the armored car to it, and it just pulls the whole front off the house and it all collapses. And it's like, But there are cases where they have done that. So that's more about the less dynamic type one. And we talked about the 5 agencies, and you were asking about the no knock on the pass. The fifth question, barring any other stuff about the service anybody may have, number 4. The fifth question I had was, are there parameters, locations, or times around serving a search warrant? No, we've talked about Tennessee does have day or night service that is applicable, but we do not advocate nighttime unless that's just what fits that situation. We're not ever going to tell you.
So I'm unclear on what that means. It sounded like you were saying you simply, as part of training, discourage the service at night.
Yeah.
But are you saying it's also part of the presentation to the judge, and a warrant must be marked as night?
No, sir. No, sir. It doesn't like that. If I go and get this warrant signed and the judge goes, here you go, officer, go execute, I can execute it that night or whatnot. There is nothing in there that stops me or has to be listed in there to do that. But I always teach the kids when we do it, just because you can serve it at night, should you serve it at night? Well, no. I mean, what's going to happen if you kick in somebody's door, late at night? What would you think? You're like, well, somebody might be, yeah. So if that's what's required, maybe you've got a hostage situation. Yeah, by all means. But, just because you can, should you? In other words, it's use common sense. It's kind of how we just kind of approach the situation on the whole thing. So there is no parameters on where a warrant can be served, provided you got the particularity or the probable cause standard. There's no place it's off limits. But again, we kind of approach this common sense. Do you see big wheels, Barbie cars? Are there a bunch of pit bulls out in the front yard? Does it look like somebody's using oxygen within the house? A medical situation, find out what you can about the location and just use common sense. We can use forcible entry, but Tennessee has, like I said previously, unnecessary damage can be considered a violation of what they considered Article 1, Section 7, which would be our Fourth Amendment. And they have excluded in the past on that. As far as, that's kind of all I have for that number 5. It was kind of short and sweet and to the point. The last one I have, number 6, what is done with evidence obtained during a search warrant? It kind of goes back to what you said. It varies judicial district to judicial district. In most places, the sheriff's department and or the agency maintains the evidence room. And whenever an officer, even though there is a statute in there that says a search warrant is a writing in the name of the state that commands an officer to go forward and bring forth evidence back to the magistrate, we kind of advise them that doesn't really mean show back up at the judge's house with whatever it is you're getting. You book it into the evidence accordance to your policy. And in Tennessee, based upon the judicial district to judicial district, most of the time the law enforcement agency handles the evidence rooms, but in some places the DA handles the evidence rooms. So they're advised to, unless it's something that has to go out to a lab to be tested, you submit the evidence that's going to be used in accordance to your policies. And we maintain that one. When you get on the scene of a search warrant, we typically try to have somebody assigned as a team that is known as like the scribe. And I'm fair, this is probably pretty common knowledge. It's one person that works in a centralized area. If it's evidence that can be brought in, and they work on a sheet that's done in like a carbon copy style. And they log in all the evidence found in room, whatever, such and such, and they log it all in. Whenever all that evidence is logged in, one copy stays behind at the custodian's house or wherever, whoever's in charge of the house. You can also just leave it in the house. They found that's acceptable. And then the other 2 copies, one goes back with the officer, and then one's filed back with the judge on the return to show what evidence was seized out of that process. Naturally, if it's blood evidence or stuff like that, you're not always going to be able to have it brought to that central location. But for most of your material items, you can bring it and describe and log it in. It's documented that way. That's kind of all I had outlined in that memorandum. Everything I've talked about is in a little bit more detail in that book that's making it around. Y'all are welcome to make copies of it. I'm happy to give you a card and you can reach out. I'll give you what I can get on it or just whatever I can do. If anybody has any questions,
One question. You spoke, I mean, probable cause to believe that we have to have probable cause, or you all have to have probable cause to believe that there is fruits of a crime or tools of a crime or instruments of a crime.
Yes, sir.
At this facility. And if I have probable cause that there are fruits or
Evidence
tools
or
or evidence or this or that, it seems like there's a good chance that I have probable cause that you have committed the crime. If I'm coming to your place. Do you all require anything or is it different if I'm going to execute an arrest warrant and the search warrant simultaneously in Tennessee at all?
No, because the arrest warrant is still supported by that probable cause. Typically, that will not come on until they've worked the crime scene, but they could happen simultaneously too. But as long as they can confirm that a crime has occurred, it's been at this location, and there may be evidence of those things here at this location. They may not have a suspect at that time, but if they can make those 3 connections, they could still serve that location regardless of where it is.
Okay, and do you all have anything about breaking the close to make arrests? And that's what my question kind of alludes to, is that to seize a person, statute specifically authorizes in Kentucky a sheriff, for instance, to break the close, to break the door down.
Okay.
Statutorily, no search warrant necessary, nothing, just.
Yeah, right. On an arrest warrant, the rule is in Tennessee, if I have an arrest warrant that's been supported by probable cause, that's been issued by the court, and I have to go out and see somebody to bring them in on that warrant, I can go to the location that is listed as the address on the warrant. And I can, if I have to make forced entry to go in to seize that person on that one, I can, but I need to articulate my probable cause. I believe they're in there. But outside of that, if it's any third-party residence, it requires a search warrant.
And if I'm doing the search warrant at that same place, any different?
No, sir.
Okay.
Yeah. Yes, sir. In fact, as it comes around, I don't remember if it was, I believe it's Rule 41, if I'm fairly certain, and it's in that tab right there. one of the grounds that is a basis for a search warrant in Tennessee. It may be like that second or third tab. It says TCA and Rule 41.
Basic search warrants in Rule 41.
Here, I'll help you right here, sir. Yeah, right here, case law. I'm sorry. Oh, here we go. Here's your case law. On your Rule 41, right here, and I apologize. Here it is. There you go. Right here on your Rule 41, search and seizure, this deals with your search warrant. One of the grounds it has listed in there, a person whose arrest is supported by probable cause. So that deals with your third-party residents.
Okay.
In that regard. But if it's an arrest warrant, I can articulate that they're in this house and that's the address that's on that warrant. I can go into that one particular house that's on the warrant if I can articulate why I believe they're home at that time. I can't just willingly go and kick in at the door any time of day. I have to be able to articulate they are in there at that time. Sir. Yeah, I'm sorry.
Yeah, I just want to clarify, there is no requirement in the state of Tennessee to have eyes on the property prior to serving the warrant. Is that correct?
No, there is not. And that is not a law, but it is strongly encouraged as a practice.
In teaching that, and
Yes, sir.
teaching in the academy, the new hires, you are encouraging that they have eyes on, but it's no requirement, correct?
Yes, sir. Be sure everybody knows where it's at. And the reason that has, to my knowledge, that has never become a criminal procedure or a law, I guess you could say, would be sure as the world if you created that law and then all of a sudden you had a warrant for whatever reason for maybe an emergency hostage situation and be like going, I'm not able to comply with this and now I've got a situation going on. So it doesn't backstop that way, but it's not a requirement, but it is what we call a best practice. Correct.
Thank you.
Yep.
All right, we'll have Mr. McGee, I think, has a question.
Oh, yes, and thank you. First of all, good afternoon, sir. It appears that Tennessee has made substantial headway in standardizing how search warrants are obtained, as well as memorializing how those warrants are executed through some type of video-based technology. Does Kentucky have a statewide system for tracking warrants that are requested, and of those that are requested, which ones are actually authorized and executed?
Oh, does Tennessee have one? No, sir. We don't have any form of a tracking system. It's just they're kept up with judicial district by judicial district. The DAs would be the ones that you want to go to. So if you were interested in, hey, this particular judicial district, which typically is composed of 3 or 4 counties, now Nashville, Memphis, Knoxville, they're their own just based upon population. But the district, the elected district attorney of those judicial districts would be the keepers of that stuff. Now, kind of on a related but different note, we did pass a law this year in the Tennessee legislature that there has to be an accounting for use of force reports by law enforcement. And TBI will be the entity that maintains all use of force reports for force used in Tennessee.
Okay,
So
and was it ever proposed that you have a statewide tracking system? And if so, what impediments did you encounter?
No, sir. There has never been a proposal on that, sir.
Okay, all right, thank you, sir.
Yes, sir.
And just if I follow up on Mr. McGee's question, you said that the district attorney would be where you would go. Are you saying that they actively keep that, or that that's just the best chance?
No, that's your best chance of getting the answer because
But there's no requirement that the
No, sir.
district attorney maintain the kind of data that Mr. McGee's talking about.
No, sir. Well, I tell you what, here's something that's interesting that may help you, that you just kind of triggered it in my head. Unless you ask for a search warrant to be under seal or something along those regards, which may happen in like a sexual abuse case or something like that. We caution officers that, understand once you return that search warrant back to the court after serving, it is public record. So it's capable of being picked up on a public records request in Tennessee. And Tennessee has very expansive public records. Yes, sir.
You all have codified a deadline to execute the warrant.
Yes, sir.
5 days. Do you have something in the other direction, i.e., you get information that you would place in an affidavit that you think constitutes probable cause, but it's something that happened 2 years ago? I'm guessing you would tell it all. Don't waste your time. Do you have a fixed codified?
We do not have one codified. That is left up to the judges to make that determination whether or not that older information is relevant. So say if it's like an old cold case file, it could have been something that happened many years ago, and now all of a sudden it's connected to new information, and they can make that determination on a case-by-case basis. And that's a great question that you brought up. In the book that's going around, I tried to make it as obvious as possible, but we had a statute. It was actually called, I want to say it was 108 in that section, but it's in there. I get the numbers kind of confused, but it was known as the Exclusionary Rule Reform Act in Tennessee. And it's what the statute says. You will see it in the book. If you get on a Westlaw search and pull it up in our TCA, it is still on the books. And it basically says in a nutshell form, if any clerk, judge, or law enforcement officer makes a clerical error, that's pretty much a harmless error. Like the particular case that changed this was the judge was signing the warrants on his 3 copies and he put like 2 p.m., 2 p.m., 2 a.m. Just a slip. And the defense bar at that time, because it was on a homicide case, it came out in the case versus Lowe, said, hey, look, this makes this warrant fatal because it wasn't properly executed. The state started screaming, hey, we've got this Exclusionary Form Rule Act that says based upon, it was just a harmless good faith there. The Supreme Court of Tennessee struck that down and said this statute is contrary to Article 1, Section 7. We're going to strike it down. It's kind of become like a sticking point between the Supreme Court and the legislators because they haven't taken it off the book. But we caution officers, this has been struck down. Don't rely your case on it. But it's what came out in the Lowe case was our Supreme Court said, we think the best determination of whether or not something is a fatal or a harmless error is left upon the judges that are actually seeing it at the trial court level. So they took that case and they go, look, 2 p.m., 2 p.m., 2 a.m. It's obviously just a slip, but it's not detrimental to the warrant. Therefore, we're going to let it go. But this statute's been struck down. So we're going to let each court handle it. And if you disagree with it, it is appealable upward to be reviewed by a higher court. So that kind of goes to what you were saying about the age of the stuff coming in. So if a judge determines, hey, this is factual, even though there's a thing, it could be one of those things that could be challenged by the defense bar.
I will say, because I actually handled that Lowe case.
Oh, did you?
In the Tennessee Supreme Court, Lindsay Lowe, that really was getting at sort of those clerical errors. And so they said that statute's not constitutional, but the judges can find that those errors are harmless. But it really is, I think they indicated it's those minor errors where it's obviously they put AM and they meant to put PM. One of the things to note about Tennessee is that we do have, as Scott mentioned, we have those statutes. We have Rule 41 that sort of designates what courts have to look at in these warrants. So while the internal review for each district might be a little bit different, the courts really hold them to these rules, the time limits and the various limits in there.
Any more questions for Mr. Well? Okay.
Yeah, sure.
One more, and this actually might be for Ms. Price or Mr. Spangler. What are I'm former appellate defense counsel, and so I think in terms of criminal appeals, there are always kind of hot issues in appeals. Is there anything related to Fourth Amendment law that you would see as kind of evolving law in Tennessee or decisions that have come out recently that would change any of this, or has it been pretty stable in recent?
Well, I think Scott already mentioned this, and I would just note that regarding the no-knock warrants, that the legislature recently made explicit what was implicit all along. They enacted a statute and say you can't write a no-knock warrant. So I would say that's fairly new, and the other legislation that you were talking about, the use of force. But I don't know.
And then the Tuttle case that he mentioned that adopted the Illinois gates and dumped the Aguilar-Spinelli test. The Aguilar-Spinelli test is still relevant. It's just not the end-all be-all for questions of confirming information for the purpose of a search warrant. So that's probably our most recent sort of flagship case on search warrants. But that's in the book as well.
Yeah, I'm glad y'all brought that up because we do, like she said, and he said, we have that new statute where this year alone, it's 105, I believe it is, where it says if probable cause is found, a judge shall issue. So it winds up being one of those things that the judge may not, for an example, if it's somebody that's in support of legalization of drugs and it's a drug warrant, it's a shall issue. It has to be done once that probable cause and the particularity and the examination occurs. It has to be signed up. That's the warrant that they this year attached subsection B that said no judge shall issue a no-knock warrant. And we were of the opinion that was implicit all along, but they finally just put it out there. Bam, there it is, black and white.
That's a better situation, though. I realize no-knocks are very controversial right now, but the way Tennessee's doing it, it leaves it up to officer discretion as opposed to getting independent third-party review.
If the officer makes a bad decision, you got to, that puts you in a bind, and a search, it could have been a good search, becomes a bad search.
Thank you, Mr. Wilder. You've certainly inspired a lot of good questions from our members, and appreciate your presentation, and thank you all, Mr. Spangler and Ms. Price as well.
No, thank you for having us. Absolutely. Appreciate it. If I can ever be of assistance, just let me know. I'll certainly pass a card around or two if anybody wants one, and anything I can help with. This book I'm leaving right here, it's for y'all. Feel free to make as many copies of it as you want. Anything you want out of it.
Thank you all. Please tell General Slatery we appreciate you all making the trip here as well.
Thank you, thank you.
Thank you very much.
All right, unless someone needs a quick break, we'll roll right into the next presentation, if that's okay, just for the, make sure we keep this moving along. We're going to have a presentation by the FBI Louisville Field Office and Supervisory Special Agent, Mr. Tim Beam, and see Brian Jones as well. So thank you all for being here. The presentation will discuss the search warrant process utilized by the FBI. It will touch on judicial, prosecutorial, and law enforcement training, and will examine aspects of the search warrant process that are unique to the federal government. Gentlemen, feel free to take it away.
Good afternoon, everyone. So my name is Brian Jones. I'm the Assistant Special Agent in charge of the FBI here in Kentucky. So essentially, I'm over all criminal investigations throughout the state. Just a little bit about my background. I've been an FBI agent for a little over 19 years. I've worked a lot of violent crime cases, drug cases, violent gang cases. I've provided supervision on public corruption, civil rights, and white collar crime cases. So pretty much everything in the criminal realm I've had quite a bit of experience in, including writing and executing search warrants for a variety of matters. And I'll turn it over to Tim Beam. Tim is our Chief Division Counsel, meaning he's the head lawyer for the FBI here in Kentucky.
Hi, good afternoon. My name is Tim Beam. I'm the Chief Division Counsel of the Louisville Field Office. My experience has been similar to Mr. Jones. I've been an agent for 19 plus years, have investigated numerous different violations from terrorism to white collar crime to public corruption, supervised a white collar crime, civil rights, public corruption squad here in Louisville, and then moved over into our legal side. Today I have kind of like 4 general topics I want to cover with you guys. And look, the biggest thing is, if you guys have questions, we're here to try to do the best we can to answer those from the federal side. Don't hesitate to pop up, and don't wait till the end of the presentation. We'll take questions as we go, because we want this to be as informal as we possibly can, and be as informative as we can. So the first thing I'll talk about is our training that we go through with our agents about the what probable cause is, how you get warrants, how you serve those warrants, and then what happens after the fact. Then we'll get into how we plan and serve those warrants, and at the end, what happens after the fact, and like what do we do in that regard. So I'll start with the training piece first, and for us, we send new agents to Quantico, Virginia for 20 plus weeks for training, and in that they go through an extensive amount of legal training. So whether they've had an extensive background of law enforcement or former attorneys or whatever that is, everyone gets basically a refresher and an explanation of what their role is in the federal law enforcement process. And so the big thing is we have about 70 plus hours of just Fourth Amendment law practice and execution for us. And so in that, we also have an extensive amount of legal document writing, and that primarily stems from affidavits, search warrant affidavits, Title III affidavits, and arrest warrant affidavits. And so in that process, we go through what is probable cause, what is the need for that, what that looks like, and how they formulate that together. And so we do that through a bunch of different practical exercises as well. There's about 40 hours of practical exercises where we take that legal training and then have them go apply it. So that means they're going to seek approval for an arrest or a search warrant. Then they're going out and planning that, and then they're going to what we call Hogan's Alley, which is an area on Quantico that is designed to be a city in everywhere in America. And so then they're critiqued on that. And what could we do better? What was a challenge? What should we do differently? And then they talk about that, and then they go do it again. And so we hope that process prepares them at least at a baseline. So when we send them out to their field office, that they can kind of come in and be at least an effective new agent. But the training isn't over there. So that's the baseline. And so we send them out, and we understand that, hey, look, everybody has different experiences, and someone who has an extensive background in law enforcement or was a state prosecutor or was on the defense bar, they have a good understanding of that, but some don't. And we have a lot of different backgrounds in the Bureau. So they're assigned a training agent that's a senior agent that has a lot of experience in these areas, and they're working with them on their investigations in order to make sure they don't step on any landmines or have any issues with how they put their case together. So any document that they're writing, whether that's an affidavit or what we call a report of an interview, an FD 302, that training agent is working with them and reviewing that and peer reviewing it and making sure it's to our standard. And in that process, it continues up the chain of command to their supervisor. And then depending on what the case is, there might be Chief Division Counsel review if it's a novel issue of Fourth Amendment, or there's some kind of concern with what they're requesting. But automatically, the Assistant United States Attorney responsible for that investigation is going to review affidavits before they go to a district court judge every time. And so we have prosecutors review on all of our affidavits before. And the way the process works is we send the affidavit over. When we think it's in a final form, they'll do a review of it, and there may be some changes. Believe it or not, as a lawyer, I can say this. They may happy to glad some things. They may change how you exactly word some stuff. They may wordsmith it a little bit. So you'll get it in that final stage, and then they'll make the appointment with the district court judge. And at times, depending on the length of the affidavit, it may go over in advance of the agent arriving. And so the agent's not going to show up there with a 30-page affidavit and expect the federal judge to, take all the time to read it right then while they sit there and wait for that determination. Those will go in advance and allow the federal judge to take a look at it, maybe have their clerk do some research, and then you better be ready for some questions because the district court judge will have some about what you're doing. And so that's kind of generally how the probationary person kind of gets through the process. And then we have a mandate that we have a 2-year probationary period for new agents. And we mandate that they're involved in the execution, the writing of, the performance of things related to search warrants. That way they have a well-rounded experience at the beginning. And so that process continues on as they become more experienced agents. So we make sure we get that in early on. And so that's kind of the training piece, and we're always learning. And so my job as the Chief Division Counsel too is also to stay up on Fourth Amendment issues. Someone raised it like, hey, what's the new hot button issues? For us, we're looking at long-term surveillance. The Supreme Court has gone to kind of a different trespass theory on that. We've got to stay up on that. So we got to make sure that, hey, look, our long-term surveillance platforms are not violating those kinds of things. So it's my job to go out and continue this long-term training throughout the year on hot button cases, questions of law, Fourth Amendment issues. And so we kind of continue that process along the way, even, agents that have 20 plus years. And so the second phase for us is now the planning and the operation of the search warrant. And so I'll say this at the beginning. For us, a search warrant is very rarely the beginning of an investigation. And so for us, on the federal side and from the Bureau, is the search warrant is generally the culmination of a long-term investigation, right? So we've done everything we possibly can covertly, whether it's using informants or doing surveillance or doing interviews or whatever that looks like. Because once we kind of throw up the flag that we're directly involved in, and we go to a door with a search warrant, the jig's up about us being involved in investigating this activity. So we generally have an extensive amount of information before seeking a federal search warrant. And so that makes it, sometimes a distinguishing factor between, state and local execution of search warrants and our execution, because a lot of times our investigations tend to be more long-term, maybe somewhat proactive and not as reactive as some of like the homicide search warrants that need to be done that are done in, snap of the finger and being done very fast. So that's an important kind of distinction for us in what we're doing, because I always tell everyone that comes to me with the search warrant, like, look, the best defense of your case, your prosecution, and the people doing the operation is a great investigation. It starts there, and it starts with the evidence that you've collected, and then we go forward what techniques to be able to use. And so that's an important thing to kind of consider. And so for us, it's then a process of then melding that evidence into something a district court judge can digest and understand if probable cause exists that a federal crime has happened and that evidence or instrumentalities of that crime is present in the location you want to go search. Okay, it's pretty simple. And so we then take that simple thing and turn it into a 20-page affidavit. And so how we do that is really, really important for us. And so it does get a lot of review internally before it goes out the door. But the AUSA kind of has the final approval before it goes to the district court. And so the big thing too is that once the affidavit is being written, there's another process that is happening too simultaneous to that. And it's what we call our operations planning phase. And so we call it an FD 888, and it's an ops plan. And it's basically getting the front office's approval. That means executive management, supervisor, and then at least an assistant special agent in charge within our office, that we're going to go do this operation. And here's how we plan to do it. And so on the criminal side, it would go up to Brian, and Brian would review that process. And what that ops plan does, it lays out the who, what, when, where, and how we're going to do things. So who's going to go, what we're going to go do, why we're doing it, and then how we're going to actually do that process. And that means, like, so we're listing the agents involved, what the case is about, whether executing an arrest or a search warrant, where it's going to be located. And then there's a couple things that are mandatory for us. Our deadly force policy is always in the ops plan, no matter what. So it's always in there, and it always has to get briefed. And I'll talk about that in a second, just so everybody kind of realizes what, as a reminder, what that policy is. And then there's always a identification of where the closest medical facility is in case there's an injury. And then it'll talk about contingencies. So what if they don't come to the door? What if they barricade? What if they flee? What if so they have to go through these contingencies and write them to a degree where Brian and the executive management for our office feels comfortable that we can do this safely. And so there's numerous times that those get kicked back for maybe a lack of specificity, or, hey, look, tactically, I don't know if this is the right way to do this, or how you're approaching this, or what that looks like. And so for us, we kind of put a lot of emphasis on that before we go out and execute it. And so one thing I forgot to mention too, in our affidavit writing, so there's the probable cause part, and then there's what we call the attachments. And the attachments are a photograph of what the location is to make sure you're hitting the right place, and then a list of what you're actually going to take. And so that way the judge knows that, hey, look, probable cause established, these items are in this location. And then similarly, in the ops plan, we're going to put in photographs of the location that we're going to hit, what we're going to serve on. That way, everybody on the team has a great understanding of what we're there for and why we're doing this and who we're doing it to. And so that gets reviewed. So when the search warrant goes over to the judge and gets approved, we're having a briefing on the ops plan itself. And so everybody who's responsible for that execution or that service is at this meeting. And we're talking through what the plan of attack is. And so the case agent that's responsible for that will brief the substance of the case on what we've learned so far. And then they'll talk about the service or how we're going to go do that. Who's going to be where, what the responsibilities are, where we're going to meet to do the pre-brief, and then who's going to be responsible for knocking and announcing and those kinds of things. And so we get all that laid out. way ahead of time. And if there's some contingency that is concerning to ASAC Jones, it might lead to our use of our SWAT team or some kind of advanced team. So I'll let him kind of explain that just for a bit, and then we'll go back to the service part.
Sure. So I heard before the talk of the matrix, right? The threat matrix to try to determine whether or not it's mandatory to use a tactical team. And now within the FBI, we do have some things that would trigger a mandatory use of a SWAT team. But typically, we're looking at every individual case. We're looking at what is this person's criminal history? Do we believe there's going to be weapons inside the residence? Does the person have convictions, or have they been arrested for assaulting law enforcement officers? Are there automatic, I think I mentioned that, automatic weapons or just weapons in general? And we look at things like, are they known to flee from law enforcement? So again, some of those can trigger, if there's multiple, something else I should have mentioned, security systems on a house or barricaded. We have source information that a subject might barricade their door, or they have bars on the windows, guard dog, what would be termed as a guard dog. All those things, if you have a certain number of those, we may have to use a mandatory SWAT operation. However, a lot of times we just decide internally, like, look, this is a pretty dangerous person. This could be a tricky operation. Let's go ahead and use a tactical team for a certain search warrant or arrest warrant. Those operations plans, as Tim talked about, most of the standard agent arrest plans, meaning when a squad would go out and execute a search warrant or an arrest warrant, I would be the final approver for the operations plans. When it comes to a SWAT operation, the head of our office, the special agent in charge, is the final approver for any kind of SWAT operations. And as we move along, if there's questions about some, I know we heard from Tennessee, and they're pretty far in the weeds about exactly when they're pulling up to a residence, and is there medical, is there EMS on scene? We're happy to answer those questions as you have them, as far as regular agent, when I said regular agent arrests and search warrants, or using a tactical team such as our SWAT team.
Okay, similar to that, Brian brings up an interesting point for us, is that so when they're in the planning phase, they've done the investigative work to establish this probable cause, but now there's also an investigative aspect on the execution phase. That means additional surveillance of the location, because we're looking for the things that he described. Are there dogs? Are there, I think the gentleman from Tennessee mentioned, is there an indication that there are children present? Because it may change when we decide to do that. We may wait until school bus comes by in order to have the children not be present for this. So all those things kind of come into play. So just because you're kind of done with the probable cause piece doesn't mean the investigation doesn't continue, because we want to make sure we have a significant amount of information, as much as we possibly can, about who is inside, what that place looks like, what we're going to encounter, and whether that means we're getting on Google Maps to look at the way the layout of the house is, or whether we have to, depending on the rural area, we're sending our plane over the top to get aerial photographs, whatever that takes to make sure we're executing that safely. And so there's a lot of things that go into that. And one of the things he mentioned too was one of the new trends is we had 2 agents unfortunately killed in Miami a few months ago related to the use of a doorbell cam. And so we have agents going to execute a search warrant that we have done hundreds of thousands of times on a child exploitation or violent crime against children case that have done numerous times. And so when they stack up on the door, the subject sees them on the Ring camera and then decides to open up with a rifle. And so now there's some special consideration on how we're doing our surveillance, what we're looking for in order to identify those doorbell cameras or other surveillance cameras that give the subjects of our search execution an advantage against us, a tactical advantage. And so, and then how we mitigate that is something that we're discussing, whether it's a technological fix or whether there's something we can do to make that interoperable at the time of the service. And so that stuff all goes into the planning phase. And that's things that ASAC Jones is going to question. That's things he's going to ask questions about and make sure that the agent and the supervisor that's running that squad have thought about in order before we go out and do that. And so I'll talk a little bit about the rules on service. I think Tennessee had the 5-day rule on once they get a warrant having to serve it. The federal rules of criminal procedure give us 14 days. I can't think of a time that we've used all 14 days. I mean, pretty much when we're getting the warrant, we're planning it and we're going to try to get this done as quickly as possible. But it does give us a little bit more time to make a good, solid decision on that.
Yes. And sometimes like an example of that where it might take longer is if we're in a long-term, say a Title III wiretap investigation, and it's targeting a gang or a drug trafficking organization. And so we know we're going to take it down at some point. We're waiting for the right time, and we may still be monitoring telephones, but we have that leeway of up to 14 days to execute it at the time that we believe.
Yeah, there might be we're waiting for an intervening event for that.
Going in the other direction, at least by reputation, the FBI is pretty notorious for being patient in their investigations.
That's fair.
So how long do you want, do you have anything fixed about how long you can hold before you present?
I think that's a great question. And I think a lot depends on the type of case. And I think the case law has been really, because the issue raised is what we call a staleness question, right? And so whether your probable cause has become stale because you've waited too long. And that is a worry for us because we do tend to have long, drawn out, year-long investigations. It's about what kind of case. So if it's a drug case, think the item that you're looking for, if it's a perishable thing or something that's transferred quickly, that time gets significantly shorter, and whether on the utility of that probable cause information, right? If it's a question of some big item that isn't transferable, or maybe it's even documentary evidence that businesses keep over long periods of time, then that period of time gets exponentially longer, right? And so there really isn't a standard on that, but I think it depends on what that looks like. But I can tell you this, if it's drug evidence that's weeks, months old, courts have been very skeptical about using that. So for us, we tend to what we call freshen up that kind of probable cause by going back in and doing additional drug buys or having sources or surveillance identify that information more recent in order to be able to articulate to the court that, yes, the items we were looking for are there now. It's not about being there 6 months ago. It's about being there. Hey, look, we know that when we go in there, we're going to find that material. That's a great question.
So in essence, there's an algorithm, but it's an algorithm up here.
Yeah.
In your head, in the judge's head.
Right.
About what makes sense in context.
Yeah.
So it's what an agent can articulate in writing within the four corners of the document that's going to the judge.
Yep. And so the courts have been very consistent about making determinations on, the subjects involved, what kind of criminal enterprise that they're running versus single off incident crime, or drug versus white collar crime versus violent crime if you're looking for a weapon or things that are transferable. So I think it's a great question. Okay. So another big thing that I found interesting from Tennessee was their warrants are basically day and nighttime service automatically. Okay, so that's much different from us. And so ours are daytime service only. That's actually written in the Rule 41 of the Federal Rules of Criminal Procedure. And that for us is 6 a.m. to 10 p.m. And so if you're going to deviate from that, you have to get court authorization to do that. And so there might be good cause, or there might be some explanation of why we would want to do that. I'm trying to think if we've done that in the time I've been in our office, probably 14 years now, and I don't know if we've done a nighttime service off the top of my head. It's very unusual simply because of the dangers that come with it, right? And so for us, the cost benefit analysis for us doesn't tend to trend that way. There'd have to be some great explanation for why we would want to do that, and not mean it's not possible. It's just not something that we seek with any real frequency.
And that's, and I can speak to it a little bit too. I think in my 19-year career, and a lot of that working drugs and gang violations, I think I was involved in executing warrants outside of normal hours, maybe 2 times. And those were special circumstances. One of them was a known drug location, and we knew no one was there. We'd been waiting and waiting and waiting for someone to come home to try to execute that warrant within the hours, but we had the judge's authorization, knowing that we didn't think someone actually lived there. It was just a house where things were stored. So there are sometimes special circumstances, but it's very rare for us to ask for that. And we would have to articulate that within the affidavit that goes to the federal judge asking for it ahead of time.
And then the judge would on the warrant note that it's basically an anytime service. And so that would be noted on the warrant itself. And so similarly, I know the discussion with Tennessee on no knock was pretty interesting for me to listen to that too. So for us, it is a mandatory requirement, U.S. Code 18, let me make sure I get the code, 3109, that we knock and announce. Okay? And the Supreme Court has basically made some exceptions to this in the sense of, you know, when it's the same kind of reasons that he described too from Tennessee, is like when it's really like unreasonable, when the individuals know that you're already present, it's a futile gesture, so to speak. When there's a reasonable suspicion that there is a danger, a direct danger to the agents executing that, it can be a no-knock of that, or if there's reasonable suspicion that the evidence is being disposed of. And in an arrest warrant context, that there's flight that will not be able to be stopped in order to be able to apprehend the subject that you're looking for. And so for us, we tend to seek out judicial authorization of any no-knock warrant for us. And again, in the time I've been here, I think we've done maybe one in the 15 years. I mean, this is an infrequent thing for us. But just because you don't get a no-knock, I think you may have jumped, sir, you brought this up. Just because you don't get a no-knock doesn't mean that on the execution phase of it, if those factors come into play, we give our agents the ability to kind of protect the evidence, protect the case, protect themselves in order to address that situation. So if they don't have a no-knock warrant and the circumstances surrounding it turn into a situation where that's needed, they have the ability to do that. Okay. Now, it's kind of like what ASAC Jones mentioned. It has to be then articulated to the court on why that transpired the way it did. And that stuff happens after the fact. But so I just want to kind of cover that for us. We tend to do.
Your officers wearing body cams?
Okay, it's a great question. So I don't know if you saw in the news recently, the Attorney General has made it a Department of Justice mandate that all of our law enforcement entities are going to body cameras in tactical situations. Like this would be one, arrest warrant service, search warrant service. But that's not a thing right now. So we're mandated to come up with an FBI Bureau-wide policy in order to kind of explain how we're going to do that. ATF, DEA are doing similar things. And it's just now a matter of formulating a policy and then honestly getting the equipment and then figuring out how we're going to do storage, how we're going to pay for it and do the technical things. But so yes, we're a little bit behind, I think, some of our state and local law enforcement partners on that. But we're definitely moving in that same way. So, okay. So once we knock and announce, you know, the question of then how do we get to a determination on breach? It's kind of case specific. So like we talk to people all the time, like, hey, if we're doing a white collar document search at a business, you know, we do a knock and announce. Does it make sense for us to just ram the door when we think, you know, hey, no one's came to the door right away? That doesn't make much sense. I mean, we may have the ability to do that, but does that make sense? It might make more sense to call the business owner and say, hey, look, we have a search warrant. Can you bring the keys down here so we don't tear up your door? And that's how it generally works. But we do in situations where we're a little concerned about drug disposal or evidence destruction, you wait what's called a reasonable amount of time. Again, I think that's a sliding scale depending on what kind of case it is and maybe the individuals you're dealing with. And so that might go into from a 20 to 30 second issue to maybe a few more minutes if the place is palatial and it's going to take somebody that long to get to the door to be able to address you at the doorway. And for us, we tend to, when we're not doing like a SWAT team service, our squads tend to be very slow and methodical. It's knock and announce, even if you're breaching the door or not, you know, you're announcing your presence and we're generally calling people out in order to make sure we get everybody out of the residence. And then even when we're going through the residence, it's very slow and methodical to make sure that, you know, it's not something you're going to see in a Mission Impossible movie where there's like 7 flashbangs flying around and we're jumping in through ceilings and that kind of thing. So it's very slow and methodical to make sure we're safe And then and we're really trying to protect the participant, everybody involved in the actual execution. And so for us, once we then get to a place where we feel the place is secure, the actual search happens. We tend to take search photos beforehand. Before anybody does any searching, everything is photographed from the outside of the residence to every room. And then the search happens. We generally have 2 people in a room to do the search, to collect evidence. It goes to a similar person that the gentleman from Tennessee mentioned. We have an evidence custodian that comes and accepts all the things that we've taken. And then their job is to basically write a receipt. The information is then collected. We finish with exit photos to make sure we leave the residence in the same format that we had found it. And we leave a copy of the warrant, and we leave a copy of the receipt of those items that we've taken. And if the person is there that is kind of the homeowner or the subject of the investigation, and they want to kind of look at that, we'll talk them through that. They generally don't want to take us up on that and talk about the evidence that we're taking, but sometimes they might. And then we return that to our office. And so our evidence goes into our evidence locker, but then we then take a copy of the receipt and then discuss that with the federal judge, and that gets filed as the search warrant return. And that way the judge knows that, look, I commanded you to do a search at this location for these things. Did you do that? Okay. And so that's our basically way of kind of closing the loop with the federal judge that, hey, look, we did do what you indicated. And sometimes it might be where we don't have a situation where we go attempt to do an execution and the items aren't there, or the car, we can't locate the car. We have to go back to the federal judge and say, hey, look, we didn't execute this warrant because we were unable to locate this vehicle or this individual or what that looks like. And so we have those conversations with the federal judge in order to make sure they understand that, hey, look, you've given us this authority, and here's how we acted upon it. And so that's kind of the basic process from the Bureau goes through, from the beginning, from training to the planning to the service to what happens at the end. We'll be more than happy to answer your question. Yes, sir.
Curious about the debriefing you do with the judge at the end. What does that look like, and is there any sort of formality or written record of that?
Yeah, so the written formality of it is like there is on the back of the warrant, it has a return phase, and we can do one of two things. You can either handwrite in exactly what you took, or generally what we do is we take that document and then we just basically staple the receipt to that. And then that gets filed with the search warrant, the application, the affidavit, with the clerk, with all that goes together. And so most of the time the judge will take a look at it and it won't be an issue. They may question like, hey, look, what'd you find here? I mean, sometimes they're just kind of interested in like, hey, they read the affidavit, they're interested in the case a little bit. They may have some questions about, well, you didn't find X, Y, and Z. What about that? I was like, well, we just didn't find it. So it's relatively informal. There's no like swearing in or anything like that. It's more of just a thing as a final check and balances to make sure we actually went to the place we were supposed to and took the things we did.
And it's probably worth noting too, that on that form, we have to document what agent, who is the primary agent that executed the warrant, which is usually going to be our team leader for whichever warrant. Sometimes we execute multiple warrants for one case at the same time. And so you might have a different team leader for each location that is not the lead investigative case agent. So we have to list out what agent served the warrant, and then what time, the date and the time that the warrant was executed.
That sounds like a good checks and balance system. The filing of it, paperwork sounds very similar in Kentucky, but we're just having a discussion, and it's kind of if you're the prosecutor or the judge, unless you seek it out or see it in court, you'd have to go to the clerk's office to find it. So I think that's a nice added safeguard that you all actually do go and potentially have a conversation.
In my experiences were all of the search warrant documents, the original signed affidavit, the original search warrant sat in the judge's office until we returned it. So nothing was being filed with the clerk's office or the federal clerk's office until the agent came back and returned the warrant. And of course, after sitting there for an amount of time, the judge's office is typically going to call the agent and ask, what's going on with the warrant? Have you served it yet? It's still sitting here. So I think that's part of the checks and balances.
Yeah, I think that's a good point, because really the package isn't complete until the return is done. And so I think that's a good astute point to make.
In case anybody's wondering, I don't think that happens in Kentucky.
It does not.
There's a lot of piles of paper in my office, but waiting for returns of search warrants ain't one of them.
Yes, sir.
It struck me when the folks from Tennessee were speaking that the legislature has got really involved in setting out parameters and the rules about search warrants down there. And that I recall they were saying that the form of the search warrant has been prescribed by statute. And in Kentucky, the form of the search warrant has been prescribed by the administrative office of the courts. And it has struck me over the years that the search warrant process is between the executive branch and the judicial branch primarily, and that we're looking for judges to tell us what we can do and so forth. And what I hear you all describe, it sounds as though to a large measure in the federal system, you're dealing with the courts. And our search warrant in Kentucky, like the federal, it says you are commanded by a judge to go to this place and seek these items and so forth. Is there more oversight, or what kind of oversight do you all receive, or direction from Congress on how you will operate with regard to search warrants and the like? And if you have none, do you see from the whole separation of powers is a whole lot more, it's argued a whole lot more in the federal system than it is, it's brought up a lot more, I think. So how does that fit in with what you all do as you see it?
Yeah, I mean, I don't think Tim or Brian want to get into the separation of powers argument, but we do get a little bit of guidance from congressional legislation. Like I think I mentioned, the knock and announce requirement that comes from a U.S. code section. Yeah, that is a congressional discussion point. But most of like the things that we discuss come from the federal rules of criminal procedure, and that comes from the Supreme Court. The Supreme Court takes a look at that and sends them to Congress as a notice item, like, hey, look, here are the rules that we're prescribing. If Congress has some concern over that, potentially they could file, kind of go through legislative process and maybe tweak that a little bit. But most of our guidance does come from how the judiciary kind of sees our role in the addressing Fourth Amendment concerns. And so that comes from like our own policy internally about how we review it, and then how the judiciary seeks that on that end. So what Congress feels about that, I'll probably leave to them.
And a little bit of follow-up too, and I think you were mentioning kind of the standardization of the forms themselves. So and I don't know, I apologize, I don't know the website, but there is a U.S. District Court website that has all of the search warrant forms in PDF format, where an agent or the AUSA can grab that form, download it, and when they fill it in, they're filling out what district, so Western District of Kentucky, and then it's a fillable form. So that is something that the district, the court system has established for us, so that everything is consistent as far as the forms we file.
And your all's affidavits and the return, are they both part of the court record after the execution and thereby open to public scrutiny by the court, or does it take a discovery?
Okay, that's a good question. So a great majority of our cases, when they are in the investigative phase, will be sealed. And so they will not become unsealed until someone is indicted, arrested, and we have that initial appearance, and then there's a motion to unseal, and then things become open record, and from that perspective. So we don't have the same issue like our kind of brethren from Tennessee would be if when there's an execution of a search warrant and the return is done, that immediately becomes a public record, or potentially open records request have the ability to seek that. We don't have that. So we have the ability to keep those materials sealed. We unfortunately run into a lot of litigation with whether it's news entities or people seeking like FOIA requesting this information, or attempting to get the information through open records requests in like maybe a joint investigation setting. So we do have that concern as well. But from our perspective, those things are sealed until a judicial action happens on like an indictment or like that the initial appearance, those things become available then. That's a great question. Yes, sir.
I've had occasion where folks come to me as a circuit judge, even though traditionally Jefferson County, the district judges handle most of the after hours search warrant stuff. And they say it's because they're working with the feds and the feds want a circuit judge, not a district judge. And I just know there's a lot of cooperation these days between state actors and federal actors. I'm just wondering, have you all found issues with the interaction between the standards that we're using as folks in Kentucky under our state system and what you all try to do in the federal system, and how are those discrepancies resolved? That's a pretty broad question.
You want to take the first part of it? And I mean, I think you ask a very good question. And so my guidance typically is if it's a federal investigation, I want us to use federal paper, right? That way it avoids some of these concerns. But there are situations where we're working jointly with partners, and so there has been times where we seek state paperwork, state judicial authorization to do certain things. I think it depends on what it is, right? So I get a little nervous when it used to be we sought tracking warrants from state judges. It made me a little nervous when our potential subject might be wandering outside the Commonwealth. And so do we really have authorization to do that? So we just want to make sure we're kind of clean on some things. So we've talked a lot about that. I think when we seek state authorization for things, we tend to give it a little bit more scrutiny on what we're sending up, because ultimately, if we want to federally prosecute those folks, an AUSA or a U.S. Attorney's Office in the Western District of Kentucky or the Eastern District of Kentucky is going to have to look at that and say, that's okay. And so it's not the idea of writing a one sentence like, okay, yeah, I know this is here. So it means like, hey, look, we're taking some time and being a little bit more robust on how we're describing what we're doing. So yes, I mean, that interplay does have some challenges because I do think in reactive situations, we're working a little faster to go seek state process. It makes it a challenge if we don't take our time and really articulate it the way we would normally do, because what I don't like to see is, hey, you're writing it one way in a state court and it looks significantly different in a federal court. If I'm going to look at that, okay, what's going on? Why are you doing that? And then they're going to play them off each other. And I think that's a problem for us. I don't think there's any like legal ramification for it because, you know, the standard of probable cause is the standard of probable cause. But I do think practically, you know, we need to make sure we do a good job of seeking federal paper when it's needed.
Yeah, and I can add to that too. So before I was in Kentucky, I worked in another state, and the magistrate judges in this particular state at the state level were not required to be attorneys, and there'd been a lot of problems with some of the magistrate level state warrants, which then would sometimes filter into federal court. And so the U.S. court, district court in this particular state mandated that the FBI or any federal agencies were not allowed to, they viewed it as skirting the federal system if we went to a state magistrate judge, if we were involved in the case. Now, we could adopt cases if state or local law enforcement had gone through a magistrate judge. But because of my experiences there, whenever one of the supervisors talks about, hey, we want to use a state level warrant here, I start to ask a lot of questions. And one of the primary questions is the U.S. Attorney's Office on board and okay with us? Because there are reasons sometimes we may not want a subject to know that the FBI is involved. We may want to use a task force officer to obtain a state level warrant and execute it to make it look like it's a local or state law enforcement warrant execution rather than the FBI. But there are absolutely circumstances where it's appropriate. But we do ask a lot of questions on the front end before we move.
That's a key thing to know. Like, so the Federal Rule of Criminal Procedure 41 requires for a federal agent to go seek a warrant, it has to be a U.S. District Court judge, a U.S. magistrate, or it could be a state circuit court judge if those other two are not available, right? So for us, I always worry that I don't want the federal judiciary to think we're forum shopping, right? That we don't want to say, hey, look, we think you are going to review this with too much scrutiny. That's not it. There are opportunities tactically for why we do certain things on whether it's, not wanting a subject to know, or we're trying to get a level of cooperation from someone in a different way. And so there is an opportunity to do that. It's just, it's a limited one. A great question.
I guess what I'm curious about, you've had a lot of years working in Kentucky, and it sounds like your all's overarching goal is to make sure your process is robust so the evidence holds up upon review. Is there anything that immediately comes to mind that this committee could try to recommend for Kentucky where you think it would be really nice if you people would do the following thing in Kentucky, because that would give us a greater comfort level about the robustness of what Kentucky does?
I don't know if there's anything specifically I would say. I mean, I think what you're doing and taking in all the information from a bunch of different entities, I think you're going to hear things that you're going to like and that may work for Kentucky. I don't think Brian and I are here to tell you what the best practice is. I think we're here to tell you what the FBI does and what the federal system does. If you like something that you think works for Kentucky, great. If you don't think it's applicable, that's okay too. Now, whether there's something in the state system that I would change, I don't know. I mean, and I'll leave that up to you guys when you guys compare things you've heard from Tennessee and from us and from I know there's some concerns about how maybe certain counties do it differently than others, and that consistency aspect of it. There's going to be things that you hear that I think will be successful across the Commonwealth, but I'll let you guys kind of make that determination.
Any other questions? Thank you, gentlemen.
Thank you all.
Thank you. Okay, looks like we've got one more presentation, and that is Mr. Steve Rocap and Troy Belcher from LexisNexis Risk Solutions. And they're going to present a demo of the e-search warrant application under development by AOC. So, gentlemen, if you all could come, and we will proceed with your presentation.
Right, hello, everybody. I appreciate for letting us come present today. Again, my name is Steve Rocap. I'm Senior Consulting Manager for LexisNexis CopLogic Solutions. And I oversee projects in Kentucky and Ohio. The big things that I do oversee is the statewide RMS known as KLOPS, which most police officers in Kentucky have used. We oversee the development of that, and also e-warrants. And then we also have e-warrants in Ohio as well that we're just bringing on. So, what we're here today is just to give you guys a sneak peek of e-search warrant application. And before I do that, I just wanted to give you a kind of a backdrop of e-warrants and what that is for those who may not know. But really, e-warrants, it was implemented in 2007, and it was a joint effort between Kentucky State Police, Administrative Office of the Courts, and Attorney General's Office. All three of those entities were development and implementation of the e-warrant system. It's currently in all 120 counties, and it's currently 98% of statewide warrants are in that system. And it has over an 85% service rate. And prior to e-warrants, that was well below 20. E-warrants is currently housed at the Kentucky State Police. It's maintained by LexisNexis under the direction of Kentucky State Police and Administrative Office of the Courts. They have a dual maintenance agreement on that, and we do take direction from both entities. And we don't make any changes to the e-warrant system until both of those parties agree. let's see, e-warrants provides the electronic processing of warrants and protective orders. It automates the process of entry, review, judge authorization, and service with a direct interface to the administrative office of the court's management system. Prior to e-warrants, paper documents were hand carried all over the city, like search warrants there for approval and authorization. Now, police supervisors, clerks, prosecutors can review and judges can authorize warrants from the comfort of their office and from their own home. You no longer have those days where the police officer's standing out on the porch, knocking on the door at 4 a.m. Because they need to have a warrant signed. E-warrants allows all that and protective orders to be done all electronically. Most warrants are signed by a judge within an hour, and roughly 30% are signed within 10 minutes. Kentucky State Police, with the support of AOC, has obtained a grant to implement search warrants into the e-warrant system. And here's the scary part for me. This all has to be done by the end of the year. The grant expires by the end of the year. It's a COVID grant that is allowing this. And so we're working really, really quickly on this project. But all the electronic efficiencies gained from the e-warrants will be brought to search warrant process, along with advanced auditing, searching capabilities, and most importantly, advanced security functionality. It's all row and permission-based security is determined who has access to what. And really the way we're treating search warrants prior to service, only need to know. That's all that's going to be able to see a search warrant prior to service. And I do know this was something that was very important to law enforcement. We're in the process of building the search warrant module with e-warrants, and we're going to do a demonstration of our progress today. Please know, this is a work in progress. It's not a finished product. And, a lot of the decisions that this group's making and the Supreme Court rule that's being discussed is going to mold the future of this project. But we just wanted to show you where we are now. And it's not perfect because, like I said, we're still, making changes, but we've made really, really good progress, I feel like. So Troy Belcher is our lead developer on the search warrant project. And he's done a lot of the coding of this and the development of this, and he's going to show this to you guys. So, Troy.
Thank you. Here we are at the home screen of e-warrants, and I'm going to get logged into the system. It brings us to the home page here where everyone can see all of their inboxes. I think some of the judges are probably familiar already with this.
I just activated the rest warrant about 2 minutes ago.
Good, it works.
From his phone, yeah.
Is there any way that can be,
That's a lot.
can you all move that up at all, or I don't know if the members can see it that well.
It's a judicial nightmare right there.
Oh, gotcha.
Sure. I'll just kind of do the best I can. Here are the top 2 inboxes. This is the review items inbox. This specifically has to do with EPOs and arrest warrants, bench warrants, and so on and so forth. This box over here on the right, it has to do with things that are sent to judges in their personal inbox. Down here below, this inbox is the new one that's been added. It's specifically for search warrants. Let me just click on that and bring up. This might be a little bit better for you. It's still kind of hard to see, but this is the search warrants inbox right here that they can go and delve into more information. This inbox basically represents the security. So imagine you have a law enforcement officer that's going to fill out a search warrant affidavit. We're giving the power of that security to that officer, right, on who sees it. So when the officer creates it, it will be in his search warrant inbox. As he sends it to the judge, it will be in that judge's inbox. If he sends it to a Commonwealth attorney or a county attorney, whomever he sends it to, that person is logged in the system as having access to it. So they will always be able to see it in their search warrant inbox.
And is that box any different than the petition for a arrest warrant box that we're currently using?
I am using this specifically to constrain any type of searches and so forth. If the person has it in their search warrant inbox, they can see it. All of the searching, the advanced searching, find a warrant searches that are found in the system, you will not be able to find a search warrant through those mechanisms. We specifically developed a database into tables that were separate from EPOs, warrants, everything. It is specifically dedicated so that there was no chance of a mistake.
They're the same, just more locked down, so
Right.
to speak. Yeah.
So that kind of speaks to the security of it. We have here the ability for the officer, if I'm logged in now as the officer, I could come over here to the left menu and create a search warrant affidavit. And just like with the criminal complaint, CPO petition, it starts the wizard. From here, what I can do is select which court, and I've got things set up for Jefferson County District right now. The different types of forms that we can do. Currently, we have the search warrant affidavit and the search warrant without notice affidavit. I'm going to pick the search warrant affidavit first. The officer would put in what agency is affiliated with, his years of service, months of service. Choose next.
And we go with the TurboTax approach to this. We walk the officer through with edits, and that's how e-warrants is and KWAPs, where you can't move to the next screen until you get it all complete. And we're just kind of bouncing through the processes, making it as easy as we can. And that's the same thing that we're doing with search warrants.
In the search warrant affidavit form, it's pretty straightforward, and we tried to mimic that as much as we possibly could. We wanted the officers to be able to enter the full text of whatever it is they wanted to enter in each one of these sections. And I can see at the top, it pretty much mirrors exactly what the affidavit is all about. And I'm just going to enter in a little bit of text just for brevity here. You'll see it at the end at the summary. What I can do is in this particularly described section, if I want, I can come in here and do a reference to say, let's see figure 1. And I can add an attachment. So a lot of times we see photos that are being added to the affidavits and so forth. He can basically put in a description of what the attachment is all about. So, and you can see we have a attachment here to the premise section of the affidavit. There is some house, and he has a reference set up in his narrative. You'll see that play out at the end of all this. In the next sections, I'm just going to be very quick. It's pretty much the same type of thing over and over and over again, where an officer is putting in some text to support whatever he's doing, and he can capture it. Again, in each one of the sections, they can add attachments. And when we get to the personal property, they can enter all that in. Now we come to the property detail, where they basically tell how the property was unlawfully used, I believe. Next. Now we come to the officer's observations. They put in the date and time that they made the observations.
the officers. Tight. The detail of his investigation. And now we come to the summary screen. Right. So what we have here is basically section by section, everything that was put in. And those familiar with e-warrants, this looks exactly like the screens you've seen before. All right. Pretty much the only difference here now is in the summary, we have a search warrant affidavit as opposed to a criminal complaint or an e-bill petition. What the officer would do now, I'm sure he would print the affidavit out. And based upon everything that.
It's not showing because of.
Oh, it's not showing. Okay.
If you unshare and reshare and just share the laptop, I think it can show. You just do a new share.
That's fine. What I'm going to do basically is just save it locally, and then I'll reattach it, and then it'll be able to show them. Okay. Gotcha.
Can I ask a question right there?
Sure.
Is the anticipation that the officer is going to get that notarized, that they're going to swear it out before they put the attachment in? So when they send it to a judge, it's basically like an EPO or check, and we don't have to talk to the officer and swear them in because they've already been sworn. Kind of like an arrest or a criminal complaint, it's already sworn out when we get it and it's attached and it's notarized. Because as right now, when we do email search warrants, sometimes they're not sworn out yet, and I have to call the officer back and swear them in, and I'm filling out. I've sworn in the officer by phone at this time on this date. So I did not know if it was planned that everything would already be sworn out as it got into the system. So when it got to the judge's inbox, that's all they needed right there.
I got you. So on the affidavit, you have to basically, like you said, swear the officer. And then.
Whether it's either going to come
Once the
sworn or I've got to swear them in after I look at it. So.
Got you. Okay.
There's been some discussion of that, but.
Been some discussion. I don't know.
It's gonna, I think when we first roll out, be the same as what it is currently, but we've talked about some, some ways to do that, electronically and things of that nature, maybe as we roll out a little bit down the road. We are allowing electronic signature of the judge for this.
Is it not being done already in a few counties? I thought there had been a few counties that had started trying to do it.
Electronic search warrants?
No?
Not yet.
Okay.
Not yet. Like I said, we're in development and, we've about got this base product done, and then we still got to do the interface with the administrative office of the courts to send the data, and then we'll be ready to go.
Electronic search warrants, it's just not being done in conjunction with the e-warrants.
Oh, okay.
We do by email.
Oh, right. Yeah, that's right.
Signatures on PDFs, things like
I
that.
thought people had told me they were doing search warrants through e-warrants, but you're saying no, that hadn't.
No.
Not yet.
Okay.
Very, very soon. You're gonna have to reshare your screen for it. It's just showing the Google screen. So if you do a new share. And then there should be one for the desktop. Yeah, there you go. Yep, there's the action.
Gotcha. Yeah, and I know, again, this is be hard to see. Let's see if I can.
Oh, Mr. McGee?
Oh, yes, sir. I did have one quick question on the search warrant affidavit, where you indicate that you upload the affidavit, and there'll be occasions where you have to go back and make sure that it's signed or notarized. In our e-filing system for attorneys, there's certain times that we have to designate that certain things were done to the documents we upload, whether it's redaction or the provision of a Word document, that sort of thing. At the affidavit stage, could you add a requirement where the officer certifies that that document has already been notarized at the time it's uploaded as an exhibit? Is that something you could add in there so that you don't have the problem of a non notarized affidavit being submitted as an exhibit to the judge?
I tell you what, I'm going to take a note of that. That's a great idea, and I'll take it back to Kentucky State Police Administrative Office of the Courts, because we're doing regular meetings on this, designing the product, and I will take this back as a possible enhancement.
Yes, sir.
I mean, let an officer check a box. I get some rookie police officer who shows up and doesn't know what a notary is and checks the box and sends it on to a judge somewhere. And it just bypasses the whole checks and balances of it, whereas they can't do that with e-warrants. With e-warrants, they have to come find someone that's authorized to administer the oath and sign it in front of that person, have that person notarize it, and then forward it on to the judge. Why would we do it any different?
Yeah, I totally agree. I thought that there was something that we said the judge had to actually swear to it. I'm looking at AOC, they're back there too. But I will bring that up for discussion. I see what you're saying. And, I'll discuss that with the design group. I'm not at liberty to make that decision. We just developed the software. But
I guess the better idea then would be a box with if you're in a jurisdiction where the judge does all the oaths, then you need a box for the judge to click that says, I swore this person in under oath.
that's what we were thinking.
Okay.
That's exactly what we were talking about.
Not
Not
the applicant.
the applicant, but the judge would say, yes, that's where we're going with it. I think there's some, and I'm not a lawyer. I think there is some things that do say that judge has to have that, that swearing before him, whether that's phone or, I think it can be done video or whatever, but it definitely is between the judge and the requester. So.
Right, unless the criminal rules allow for the judges to designate approved notaries for both arrest and search warrants. So
Yes.
it just depends on the preference of the judges in each jurisdiction.
Okay.
But it's as simple as one click. For
It
the
is.
judge.
It is as simple as one click for a judge.
We have a general order that all of our assistant Commonwealth and county attorneys can swear out warrants. So.
Yep.
One thing that would be helpful when you're developing this, and would be helpful if it was changed on e-warrants, is making all pre-printed text on the warrant appear on the page where the officer is, or whoever the applicant is inputting the verbiage. Because, for instance, on arrest warrants, the warrant, when it comes out of the printer, has pre-printed on it, a client, after being duly sworn in caution, states that on blank date, this person unlawfully, and so it's got a half sentence there, and theoretically, the applicant should be, or the appliant should be completing that sentence before they move on. None of the applicants do, because they can't see that that's there. You don't know that that half sentence is there until it comes out of the printer.
I got you.
And it, might be picky, but these are sworn legal documents that we're producing, so theoretically, we would like to have complete sentences.
Yes, and I definitely agree with that 100%. There can't be a mistake with these things.
Right, so I guess since we're going beyond just, arrest, not just arrest warrants, we're going even beyond arrest warrants now into search warrants, and these have potentially being very complicated search warrants if we're authorizing searches of premises, vehicles, and persons all in the same search warrant. I think it becomes even more important to have the verbiage be obvious and apparent and correct. The other last thing I'll add, and then I'll shut up, is we should, over half of our search warrants these days are either for computers, cell phones, or internet accounts of some kind, whether it's a Dropbox account, an email account, Facebook account. We may as well plan for the future and have those pre-printed box checks set up for internet searches or cell phone searches, things of that nature. We search a lot more of those than we do houses or cars.
Yeah.
Hesitate to use the term boilerplate, but that's what it is. It's language they stick in on, and if they could do that on this system, it would be helpful for them, because some of that runs for pages and pages, and they want to explain to you why. Facebook could help us find somebody. I don't need to read for the 57th time those 5 pages. This is why Facebook could help you find somebody.
Gotcha. Yeah, so we could have some pre-generated text like we have in e-warrants.
Yes, yes.
Yeah, that's really good suggestions. And I am taking notes of all these. Thank you.
So basically, I guess where were we? We were at the officer in the affidavit, where they could print it out. There's going to be an officer's signature. There's going to be a judge swearing and a signature. The search warrant affidavit is going to be reattached to this process here. And now what the officer can do, he can do one of two things. He can submit to the judge directly, or he could submit review. Now, I do not have the functionality for submit review, but what that is all about is that if he needs to submit it to his supervisor for a review before sending to the judge, if he needs to submit it to the Commonwealth attorney, county attorneys, so on and so forth. Anybody who might need to see this. Now, going back to the search warrant inbox, by doing that, he is conveying permission for them to see it. And it will remain in their search warrant inbox. Just so you know.
Currently envision that after the supervisory person says grace on it, says this is okay, and then you move it to the status of send it to the judge, that somehow the judge will know that that person has said grace over it? Will it somehow reflect that?
There will be a history, just like you see any warrants where you can see every action that has been taken. I don't have the history right now built into the search warrant, but it will be there because everybody looks at the history when it comes to the warrants. They want to see who created it. They wanted to see who sent it, who even looked at it. We will definitely have that information in there. The next action that can be taken is submit to the judge, which I'm going to do now. The officer can pick which judge. Now, I'm kind of acting as a dual role here, the officer and judge, but they can basically submit this off. And there we go.
And one thing to note, I believe this is being recorded, so anybody that would really like to see these screens in more detail that Troy's going through, you can watch the Zoom recording. Because I kind of raised the same issue as that TV's small.
It is small. It is small. I apologize for that. Going back to where we were now, sort my list, descending. This is the one we were working on. Notice the status is under review now. It's in the step of authorization. Okay, so this is like a judge receives it. Okay, and I know it's kind of hard to see. He could open up the warrant affidavit and view that, and basically do his ruling from that. Some judges, I think, they will visit these sections section by section. Notice that the photo of the house that we had put in here, it is listed there under the premise section. So that's what we try to do. In each one of the sections, you can add photos, supporting documentation and so forth, and it will appear in that section in which they were added. Okay. We come back up here to the top. The judge can authorize this, or he could return it to the creator. Maybe he's not happy with what's being presented. He could return it back to the officer for additional information. We can click authorize here, and what we're going to do is the judge is authorizing the search warrant, and it's building the search warrant form behind the scenes and attached it as part of this record now.
On the rejection, is there going to be an area for notes from the judge if he's wanting anything more?
Yes,
if he's going to send it back to the officer, is there going to be a pop-up box for the judge to add notes of what they're looking for?
Yes.
Okay. One, when we approve one, you almost never need to put anything, but you're saying that same note box would be there for you if you wanted to.
Yes.
Yeah,
Yes. Now that this is authorized, if I am the judge, by the officer sending it to the judge, again, it's in that search warrant inbox. Okay. You've authorized it for the officer to go serve. The judge, it is still in his search warrant box right here. Okay. If the judges want to keep track of it, they can do so as they please.
I'm not sure if that's something that you would want. I don't know. But
No, yes, so.
all the players that had a hand in
Right on.
building it, whether it's the person that created it, again, anyone who reviewed it, anyone who authorized, that is on record. So we will have that information.
Very Troy.
And that basically concludes the demonstration.
And then in terms of trying to mine data from this after a few years of basically looking for information, is there going to be an ability to get into this historical database and determine where are warrants coming from? Is there a particular officer who's had 6 rejected or something like that? In other words, how useful will this information be for people to access it later in an effort to try to figure out what do we need to do to strengthen up the system?
Yeah, we're still defining a little bit of that, but right out the gate, we're gonna have where you can see counts by county and jurisdiction and things of that nature. And we're still discussing after service, how much we should allow to be searchable by the group. I know right out the gate, it's gonna be agency county counts and that kind of stuff. Then really from our developer standpoint, we can make it anything. Like we could show each officer and how many they've had rejected and who they are. But I think, like I said, that's still being defined.
In the database itself, it will remain encrypted. Now, if it goes public or something like that after service, I'm assuming that these do go public record.
Well, that's something that can be,
I'm-
it sounds
now,
like with this
I don't know.
process, that can be controlled a little more readily than maybe it is now.
It can, and you'll have a better, what happens now, a lot of times you don't know what happens now at all.
There's a drawer with the folder with the search
Right.
warrants.
Yes.
Kept in the drawer in the clerk's
And
office.
we're talking about putting some things in here that allows that officer, if they've got one warrant out and there's been like 30 days or 60 days of no action on the one they've already took out, we're not gonna let them take another one out. So they do something with the one they've already taken out. We know you've either served this thing or put it in your drawer and you're not going to. So you close this thing before you go do another one, because we want accountability on these things. And we were trying to think, how can we do that? It's a way we can do that. So, those are kinds of things that we want, tracking.
That's not really your job, and there's no legal authority for you to do that. But, I mean,
Information is there. We can't really answer that question.
I get alerts all the time that my employees haven't logged in to e-warrants within 30 days, 60 days, whatever the time is. But locking, banning an officer from obtaining a search warrant is not the answer. That's.
I don't know if it's really banning, just go tell us something about the one you took out that's been there for 30 days. And this hasn't even been done. This is all discussion stuff.
No, I'm just telling you that if I'm in the middle of a murder
Yeah.
investigation, or if somebody's child's just been raped and we're under the gun to get this done and get it done now before the evidence goes away.
Sure.
I don't want to deal with the fact that somebody did, because who knows?
It's a
Maybe
good
you guys were wrong. Maybe somebody in the clerk's office didn't check the right box when they brought the return back or something.
You're right.
But that's not something I want to deal with at 4 o'clock in the morning or when the evidence is about to disappear.
That's a good opinion we hadn't thought about. Thank you.
One thing that
You
we
can
check.
come back and determine that it sounds like later that somebody sat on something for a long time. In other words, you could deal with that
Yeah.
without that potential roadblock that could, again, potentially create an issue. Because again, then who clears up that roadblock? You say, just tell us something. Well, I'm not sure who us is for that officer to
Yeah,
put
it's
up.
true.
I'm not saying I dislike the concept. I'm just saying, I'm not
I
sure.
agree. I think the concept's very good, to have some sort of flag after so much time to flag the fact that there's an outstanding issue hanging out there. I think that's a good idea. I just.
Locking out's not good. Yeah, I'd say.
And to be honest with you, we've tried to keep things very simple. This demo was very simple. I am definitely not trying to put bells and whistles in this because you complicate a process that needs to be perfect. Okay.
Yeah.
Yeah.
So can things be done? A lot of that is going to be up to you guys.
Yeah, right.
Well, the fact that, like the warrants, that data is there in your system, and you can go in and you can look at past warrants and type in a name or date of birth, things like that, and find stuff that was there, whereas right now you can't. you can't find anything to do with the search warrant. It's not traceable, it's not searchable, nothing. So this will be a way.
Just one correction, we're not going to allow searching for search warrants.
I understand that. I'm just saying it's there. So if somebody in the state, eventually, if AOC or if the Attorney General or whatever, if somebody could look at that information if you had to have it.
And that's why it'll be important to know who's
Who's
the
gonna get
keeper
it?
of these data bits, so that there is someone who will decide who gets to look at that stuff. and
Right.
why. Because that would be important.
The stuff you all are talking about too, it would be good if you could sort by other things like location, and then also to sort out things like the servers that Rob's talking about serving with Facebook and all of those. So that was one of the things people were looking at for service locations. So right now you can search by names, but if you can search by other things as well, that might be nice for the information they're talking about for the future.
The actions taken on the search warrant, so you have the investigator who submits it up the chain, it gets eventually signed off on the judge, that investigator then is notified that it's signed off on, they can execute the warrant. Is there any more input from available to the investigator at that point? For example, if they decide to not execute the warrant or if circumstances change, is there a means for them to then communicate on that same form up the chain again, maybe back to the judge to advise them of one thing, or to say that it's been executed, to allow the judge then to be then on notice to wait for whatever that chain of communication that goes to the court's office?
We don't do that. They don't come back to us once they've served it and say, hey, we've got everything.
Well, I'm wondering through this
that.
process, is there something that could be added to just enhance that communication, so that the judge knows in, real time what's happened, that it's either been executed or not?
They can go to the history, see that.
Yeah, but broadly stated, we don't interject, we don't care. I mean,
We care, but we don't.
It's a job to see how your investigation goes. Like, when they talk about these federal judges talking to these FBI agents, and I'm thinking, well, if the federal judge ain't happy, and you never want to make a federal judge unhappy, but it's like, what's he going to do? Scold them? I mean, as a practical matter, what am I going to do? If I think this officer has done something inappropriate, what am I going to do? There's no case in front of me for me to inflict some kind of consequence.
Yeah, I didn't mean to.
But I'll give you one example that would be good. A lot of times if we're going to put a tracker on a vehicle, it's for X number of days. And then something happens and they're like, we really would like another 30 days. And it's basically the whole same bit of information, but they basically, can you give me another warrant to go an extra 30 days? Be nice if there was a way to basically come back to the first warrant and say, we're now wanting to extend this. And I don't even know if it's technically what the simplest, most appropriate way to do that would be, but you do see that from time to time where the officers need to try to convince you that additional time tracking a vehicle or keeping a tap on a phone is appropriate. And you'd kind of like to see what the original one was, which these days we don't have. They just kind of come back with a completely new set of paper. And sometimes they'll tell you, well, this is, you had it for 45 days, you need another 30 days or something like that. But with this way, it would seem like you might be able to have that whole history, which would be good.
Yes. I guess what I was thinking of is that, we've discussed when we talk about tracking search warrants and whether or not, like, do we know how many search warrants have been applied for that have never been served, and trying to keep track of that, having the ability in this electronic format to say we didn't serve it. Because in my time, there was a handful of search warrants we applied for that we never served. And, the way that that's tracked, to be able to input that may be helpful to track that. Or maybe some judges are interested in that.
Yeah, it would be nice
You can rescind an arrest warrant, so that you might send the judge a note that says, can you rescind this or recall it?
It would be nice if you did have a way for an officer to come back and say, it was executed on this date, just so you know that it happened.
That is something we want definitely to put in there. And to say these aren't searchable isn't really true. They're going to be searchable to everybody who needed to be involved in it. So the officer would be able to find it, the supervisor would be able to find it, and the judge who authorized it would be able to find it. Those will be there.
I think Mr. McGee might have had a question.
Oh, and thank you. Just very briefly, the first question I had was, Was there a particular, or what was the reasoning behind an officer being able to select a particular judge to review a warrant, as opposed to simply, for example, selecting the county and then have all the judges that are practicing in those counties or that circuit receive a notification? This is part of what we raised as far as the judge shopping or judicial shopping for these warrants. And the last thing I would just make an observation for your consideration. The information that's being gathered as part of the investigation for these warrants is not proprietary. This is not information which, from my perspective, that belongs to law enforcement. We're talking about public officers relying on public resources to gather information which impacts important constitutional rights of members of the public. So when we talk about people being, or certain agencies being gatekeepers, indicating who has access to this information and how it can be relied upon, I think maybe respectfully, we should change the perspective here. The idea is to be transparent and not to withhold information. It doesn't do any good to say the only information the public can look at is the information we decide to give them. I think once you undertake to use public resources to gather that information, that's public forum. I mean, that's fair game.
Well, just to kind of answer your first question, Ramon, I don't think there is a Jefferson Circuit Court box for e-warrants. In other words, I have my inbox, you have your inbox. Every judge has their inbox. I'm not sure there is a mechanism, maybe I just don't know about it, where the inbox belongs to the entire court.
When a criminal complaint is submitted to the judges, it goes into the review items inbox. Okay, that review items is a shared inbox of everyone in Jefferson County that can authorize that, which means the judges.
I would dare say it's typically the district judges, though.
Yeah.
I know in Christian County, they go to Judge Adams and myself to look at, and not the circuit judges, because they do have to call us and say, hey, can you activate this warrant?
Mm-hmm.
We can't do it. So, and I get, that could be easily changed, I guess,
But to some extent, this system would know that a particular police force or even down to an officer was sending this to a particular judge every time, or what have you. In other words, you could come back later if you felt somebody was judge shopping, and you could literally prove you directed this to the inbox of this judge every freaking time. It would give you the ability to track how that was happening.
I don't even think when we use e-warrants, we don't even get the option of individual judges. We get district court or circuit court, and I don't even know that we get circuit court at all. I think it's district court.
Well, it usually belongs, there's a case in existence there that's been assigned to a particular judge, so it would pretty much automatically come, like if I have a warrant issued out of my case, it's going to come to me.
but on the complaint warrant,
But just on a new complaint warrant, we don't even get individual judges.
I'll have prosecutors text or call me and say, hey, there's a warrant in e-warrants, can you activate it?
Sure.
I mean, that's about it.
We know who the on-call judge is, so if we need something activated right away, we'll call the on-call judge.
So, but I'm just saying, Ramon, to some extent, because this will keep track of that, if that's an evil we need to root out, this is going to enable us to know what's happening.
No, and I understood, Judge. I'm just a big believer, and if you don't want to step on a mine, don't walk into a minefield. So if you know that an officer, for example, on the drop-down menu can select a particular judge, you're in some ways enabling the very evil that you might be trying to avoid, as opposed to eliminating that possibility in the first place. But I understand you, I do.
And then speaking to your second part of that, I'm not a law enforcement, again, I'm just IT. We're still formulating who can see what and how all that's going to be. I think the only concern that law enforcement had was really prior to service. I mean, KSP, I think you're on if you want to jump in, but really just, I think they were a little worried about officer safety in that showing up somewhere where they know they're showing up could be a bad thing. And that was their only concern, is if it was too broadly viewed prior to service, it could put officers in danger. But other than that, I don't think, after service, I don't really think anybody has much issue after that.
Well, no, I'd agree with that. I'm assuming that once the information is submitted for a court's review, at that point, it becomes public data. As opposed to, getting that information before warrant is ever reviewed. I'd agree that it probably shouldn't be disclosed before a judge has a chance to review.
And really even maybe prior to service, really, I think is what law.
Right, or prior to service. That's correct.
Yep.
Thank you all so much.
Thank you. Appreciate it.
Thank you.
Yep.
Thank you. End of the year. Piece of cake.
It's coming very soon. Like I said, the grant ends in December, so we'll be rolling out pilot counties very, very soon, probably right after the first of the year. So it's here now. So thank you all very much. Appreciate you all.
All right, if you all don't mind, we're going to look at the minutes from last meeting, and if everybody's okay with them, can we get a motion to approve those minutes? Yes, sir.
Judge Cunningham was present on the phone from his judicial education thing, but I didn't comment, but I was present, albeit remotely.
I would move to approve the minutes for that.
Okay with that. Can I get a second? Okay. All those in favor?
Aye.
Any opposed? All right, minutes approved, given the change to note that, to reflect that Judge Cunningham was present by phone. At this moment, just for the respect of anyone that might have any comments, we'll move to a period of public comment. If there is any public comment, just to, maybe this meeting is, we've had some very robust conversations and presentations, so just want to, if there are any public comments, want to get to that before we move into committee meetings. Anyone? Anyone online? Okay, well, with that, I will dispense with all the old business, and we'll move to the new business, which is the committee meetings. You all know the deal as it relates to securing, serving, and reviewing. You know your committees. I think we'll try to jump into those quickly so that you all can look at perhaps what it might look like in subsequent meetings to lead one of these discussions and have a presentation based on what you all come up with in your committee meeting. So we'll move to those now, if that's okay with everyone, and feel free to use the restroom or grab coffee or water to the extent anyone needs that. Thank you all. And we'll try to be back here by 4:30, 4:45. Is that okay? Is that okay with everyone?
Yes, sir.
All right, thank you. Thank you. reconvene here shortly. All right. Well, if you all, the chairperson, if the chairperson would like to just report briefly on what you all discussed, we can go from there. I'll start with the securing committee.
We discussed a few things, but one of the things that I wanted to get clarification on, I know today we're kind of on a tight timeline, but there's a lot of discussion that the members of the committee want to flush out. And of course, we didn't have enough time to do that, and I understand that. So in the future, or do I need to adjust and have other meetings outside of this one? Are we going to have the time frame to deal with some deep, intense issues, or is this the common time we have after a presentation?
I think this meeting, just because we tried to fit 3 presentations in, was a little longer than
the norm. Okay.
And it, you know, I think it generated a lot of good conversation. But I think the priority going forward, and I'll make a note of this to our team, is that we will make sure we scale it back to 1 presentation, so it allows you all to do the bulk of the work and that sort of thing. So is that good?
That's good. And
Yes,
so
ma'am.
we want to move forward with getting some additional data.
Okay.
And as we can gain it, we'll report it back to the committee.
Sounds good.
Thank you.
All right. We will do the serving committee.
Primarily what we discussed is, and what we hope to work around putting together is a set of suggestions that will be suitable for very small agencies across the Commonwealth, to medium-sized agencies across the Commonwealth, to large agencies across the Commonwealth with regard to the service of search warrants, the pre-operational plans and things that might want to be included in it and so forth. So we're working on that and wanting to get examples of various agencies' policies that they may have already in place, so that we can review them and kind of cherry pick what seems to be good out of the various ones that we have come before us.
That sounds great. Thank you, Sheriff Scholler. The reviewing committee.
Yes, General Cameron, we had a basic discussion today, kind of following up what we spoke about in here, about the e-search warrants and the process. And I know Chief Monroe brought up that the Chiefs Association really liked the thought of, three-pronged, a 3-level review of the search warrant from law enforcement to prosecutor to judge. And this e-search warrant may make that a little more doable and statewide, things like that, so we can have a uniform way of doing things. And then we also talked about, I know each committee is tasked with a presentation sometime in the future during one of these meetings, and we were just talking about that and asking about specifics about what we're kind of expected to do. So Blake was helping us with that, and that's pretty much it today.
Thank you, Judge Cotto.
Thank you.
Anybody have any general questions before I make a motion to adjourn? Anyone? All right, can I have that motion to adjourn? Second. All right, all those in favor? Aye. All right.
Aye.
Have a good evening, you all. Thank you.
Thank you.
Thank you.
Yes, sir, you too.